some correction is required, madam. With paragraph number 27, madam. Kindly see, madam, your lordship was pleased to give direction upon the response number 2, madam. It, madam, it should be, madam, 3. The later referring, madam, kindly see. The later referring, madam, we are addressed to the respondent number 3, madam. The address, madam, saying, madam, 29th December, it is addressed to the respondent number 3, madam.
Who is the respondent number 3?
Madam, Kolkata, madam, the chief engineer. Not executive engineering chief, chief engineer from Kolkata, madam.
No, but I pass an order. It has to be because you are relying upon the engineering in chief's letter.
This malad, he is in malad, Delhi malad.
Maybe Delhi, whatever it is. You have relying upon the engineering chief. So this court wanted the engineering chief has to interpret his letter. Your officers are misinterpreting the letter of the engineering in chief. That's why I direct the engineering chief to consider that.
Lord,
Why you are shy to send to the higher authority?
Lord, may I have your lordship's Lord kind leave Lord to mention item number 17 and 18. Yesterday I mentioned this matter. Your lordship indicated that if your lordship does not reach Lord yesterday, Lord, I'll have the liberty to mention today. Kindly, Lord, else again it will go to the monthly list. Lord.
17
and 18.
Okay, let us see if it today reach it will right. Otherwise, it will come on Monday.
Lord, on Monday there is monthly list. Lord, else again.
But the supplementary will there. Fixed matters will be there. There is no.
The matter did not come yesterday. Now the matter is today, item number 40. 21 years, I am in custody. They have to produce the list of the convicts who will be released.
Okay, I will see to that.
May I have your lordship's?
It expires today. But I have mentioned yesterday, the item number is item number 52 of my lord's list. I have already served the notice on the other side.
Today is the last date of the entry mode. Item number
52.
Okay, let us see. Then before rising, you mention, I will explain.
I have already mentioned this matter on 29th of June. However, after the mentioning, the lordship was pleased to raise this matter today itself. But in today's delivery, it hasn't appeared.
What is the matter?
The matter is related to SIR. SIR.
My lord, come tomorrow. It will be listed.
My lord, may I permit to mention, my lord, petitioner reside in the Bangladesh border area, my lord. All are there is a check post operated by the BSF. To entry and exit, my lord, they have checked to my lord voter card, my lord. That's why my name has been deleted, my lord. They are in my lord.
So what is the grievance? SIR. You tomorrow. SIR. How 1 day 200 to 500 matters is filing on the SIR matter. How kindly see there is no space to keep the files in the court. And what if the court dispose of how the tribunal will deal with that? If this court direct the tribunal or request the tribunal to consider how the tribunal will do the first, because tribunal has to verify each and every document. This court will dispose of. I don't know what will happen.
Yes. May I mention upon notice, my lord, this is a matter where, my lord, the interim order was vacated. Our fault, we did not, my lord, but there are a lot, my lord, we need to indicate, because I was appearing virtually on that day, my lord. I couldn't make a submission without seeing, because I'm not there in the NCLT proceeding. Couldn't really make a submission. It is a wrong submission made by the other side on the order. Later, when I saw, my lord, I understood that perhaps I should have brought it to the knowledge of this honorable court. We have filed an application, my lord. The difficulties they are mentioning every day, saying there is no interim order, kindly proceed. So, my lord, may I only pray? This was, my lord,
Serve the
reinstating the
notice
interim order.
fixed Monday,
Monday.
under the ending application, talk.
Your lordship,
I'm very deeply obliged, very deeply.
your lordship,
Serve
may,
the notice, serve the
My
notice.
lord, we will.
Yes.
We have already served, my lord, we'll serve again.
My lord,
Very
your
deeply
lordship, may I have a leave to mention, lordship, I am mentioning for inclusion, there is an urgency, your lordship, the petitioner worked.
Today is not the man.
No, my lord, there is an urgency, the petitioner worked with the respondent hospital and the work is completed, also the payment is done, but they are not issuing the credential certificate. If they don't issue the credential certificate, then the petitioner won't be
certificate,
credential certificate.
credential certificate.
Then the petitioner won't be able to participate in other tender. Already the other tenders are being floated. So there's
What the court will do? What the court will do if they are not issuing the certificate? Which department?
it is a South Railway Hospital. They have in the food tender process.
If I fix tomorrow, the other advocate will not appear. The court cannot pass an order.
Your
So
lordship,
what
kindly
can be done?
keep it on Monday or
Monday to
But-
tonight.
Your lordship,
Shortly,
there-
August, there is any, you will get any space.
Your lordship, I will inform the other side too.
My lord, leave
Please,
to
lord.
file this read application.
13 August
My
को
lord,
रखो.
my lord, leave to file this SIR matter relating to my lord petitioner is a
SIR matter, no leave. You file it.
lordship, the urgency is as
I
such.
am telling SIR matter, no leave. You file it, give the notice, it will be listed.
I'm seeking your lordship's
Yes,
kindly
the list.
mention a matter, your lordship. I'm reprimanding myself.
Call
for
the
this.
list, call the list.
Your lordship, item number 50, Mr. Banerjee had already mentioned, your lordship, I have been removed from the company section 169. Your lordship will kindly take it on Monday, your lordship, item number 50. I apologize, your lordship.
Yes, who is appearing for the item number 1?
Item number 1, my lord, I appear on behalf of the petitioner.
What is the grievance?
My lord, we prefer this contempt, my lord, arised out of your lordship's judgment, my lord. Your lordship will find the, my lord, relevant portion at, my lord, page number 40 of my application, where your lordship was pleased to direct the contemptor, my lord, to refund the amount of 9,50,000 along with all original testimonials of the petitioner within 2 weeks from the date of this order, my lord. This order has been passed on 23rd June.
What is the date of the order?
23rd June 2026. Eventually, my lord, we
In
have
2 weeks.
Yes.
When you communicated the order?
communicated on 36/2026.
36/20. When they are received?
Yes.
Where is the receipt of the letter?
Sent it via email.
Where is the receipt?
42. So it's showing 1st July, my lord. I stand amended.
1st July. So
First.
15 July.
Yes.
Yes. Nobody's you are not issue notice.
Yes.
The petition has filed the present contempt application on the allegation that the respondent authorities, the alleged contemners have willfully and deliberately violated the order passed by this court dated 23rd of June 2026 by not refunding the amount of rupees 9,50,000 as well as the original testimonials of the petitioner within a period of 2 weeks on the date of receipt of the order. The petition directed to issue notice upon the respondents, upon the alleged contemners, and to file affidavit of service on the next date fixed, list the matter on 7th August.
7th August, my lord.
Yes,
My lord, under the same heading, my
after
lord.
the having contempt application. Yes.
My lord, under the same heading, it will have.
Next.
Grateful to you, lord.
71.
But I did response.
Page
71. Paragraph 3.
Yes.
Now, my lord, I'll come to 73. My lord, at page 75, I will get it will be giving effect from 1st August. At page 75, my lord will get the pay.
70?
73, kindly see. 73, first paragraph,
Yes.
with effect from 1st August 2026. Authority has the knowledge, if petition pending for long, and specific visit matter directed to place before my lord is utilized, then it will be finalized.
Yes.
They have all given effect to from 1st.
Yes.
And 75 date chart is there, you are challenging separately that.
Yes.
That is also, my lord, from 1st August. So 75 chart thereafter, my lord, just after the chart, revised dates will be implemented with effect from 1st August 2026.
Yes.
For the time being, my lord,
Yes.
this is our grievance.
Lord, I'm really at a loss, Lord, what they actually want. Lord, Mr. Basu is showing a writ petition of 2022. Lord, very কৌশিক চন্দ্র অর্ডারটা কোথায়? প্রথম অর্ডারটা জাস্টিস কৌশিক, ইয়েস, করে সাজাতেও পারো না, পরের অর্ডার আগে আপনারই ডকুমেন্ট স্যার। Lord, 2022,
Yes.
a writ petition was filed challenging a tender protocol 2022 on the ground that the revised rate chart has not been finalized. Lord, can you consider this? Yes. And this gentleman is continuously as to a government. The document. You kindly allow the petition order. Mr. Swanshaw, an advocate for the petitioner, it is a submission of Mr. Swanshaw that the rates for diet for the indoor patient admitted to the different state hospitals are being revised after 3 years pursuant to the order, pursuant to an order dated Swanshaw, number Swanshaw. Mr. Basu submitted the following the said order. The rates were revised in 2011. Broad-based committee, the said rates were revised again in the year 2014 and 17. Mr. Basu submits that the year 2020 to 25, the relevant following the rates. Mr. Basu further submits the option for the year 2020 to 2025 has rendered the payment. Since keeping in mind the price hike, the tender should have been floated only after revision of rates. So his grievance the Mr. Mukherjee and senior applicant state frankly submits that he needs time to take instruction in the matter since he has been served with the copy 1 hour ago. The petition without prejudice to his rights in view of the nature of the grievance, the petitioner, as noted above, authorities will not finalize the bid for 2 weeks. Now that this writ petition appeared before the court 15 occasions when only was extended. Only my lord, by order dated 23rd December, said that I am fixing it as a specific fixed matter and incidentally all the my lord, on 10th of April, kindly take your lordship's order dated 10th of April at Miller page 68 of the writ petition.
Yes.
My lord directed us, kindly come to 69.
Yes.
My lord directed us, panel 4, in view of the above, the state authorities are directed to constitute a broad-based committee on or before 12 June 2026. Committee shall take appropriate decision by recommending the rates chart, diet chart for the indoor patient of the government hospital and the state hospital. Once the committee has recommended of the diet of the indoor patient, the authorities shall prepare the tender notice on the basis of which this has been complied with. Committee
Subsequent order.
I'm coming to that. Committee constituted, rate chart finalized, rate chart has been approved by the authority. Not the approved said that you proceed for the tender, and we have published.
Who told you to proceed with the tender?
I'm coming to that.
I am asking one question. Who told you to
Your lordship's order was to file a
court given you liberty.
Kindly take that order. Kindly take that
Constitute a
order.
board, just a minute,
Well.
sir. Once I hear the matter, once I pass the order, I am keeping all the things in mind what the court has done.
My lord.
Correct, and 2-3 times your state has taken the time to constitute a board and to fix the rate. Then this court, I know this will happen. That's why this court has passed an order consciously after the rate is fixed. It has to place before this court by way of supplementary affidavit, so that in the writ petition with the petition enjoying the interim order, that can be disposed of forever.
Yes. Now, let case was that no rate chart is finalized, now the rate is finalized. In this present, he has not challenged the rate chart.
Why this court has called for the supplementary affidavit, the rate charge?
Not that
To
matter.
see the face of the officer of the West Bengal.
Absolutely not. What has been done by us is the rate chart is annexed in the rate. I'll have a look at it.
Why you have not filed that rate chart before publishing the tender notice?
Lord, the rate chart has been finalized on 24th
So
of July.
let this writ petition be taken up along with
Lord,
the.
kindly take this and along with the other date on Monday or Tuesday, we'll file that supplementary
Okay,
affidavit.
but Tuesday at 4:30 till night. As per your, I will take the
Lord,
matter
what has been
4:30
what
to
has
till
been done,
this was
but in the earlier, sir, nothing remains subject to correction.
your authority to read the each and every order, then you have to come to the conclusion.
My lord.
This court has heard the matter of the respondent authority.
lord.
Changing the advocate will not change the scenario.
My lord,
Correct.
my
You are not there.
my lord,
This court find that this acquisition will arise.
my lord,
And since 2022, the authority is not coming with that.
My lord.
Then to solve the issue, this court has given a liberty to constitute a board, because on that day your advocate is telling that at present there is no board.
constituted,
Constitute a board, frame the guidelines,
Framed.
fix the rates.
fixed.
If the financial approved, then
Approved.
file the same in with the supplementary affidavit, so that this court can decide if they have any objections.
Lord,
so
that
once-
matter is fixed on 20th August. I have taken instructions. We will file that affidavit on Tuesday. It might have preponed that, but not here. Mr. Basu challenge the chart.
I am not challenging it. I am only on my order.
Lord, I
If-
assume
You that rate chart which you have published or which you have approved, whether that is in consonance with, whether that can be applied. That's why the supplement. Why this court has called for the supplementary?
Absolutely.
Why
Absolutely.
the court has the court can
kindly-
only to see your frame,
kindly
you can
keep silent.
proceed with
Kindly
it.
keep silent. So from the affidavit, the law officer is present. But today, on the garb of that, now, how can he have any grievance? The rate-
This court is not against
My-
your
My
increasing
lord,
of
I'm
rate.
grateful.
This court is only once the
Yes,
court
yes.
is in session of the matter
Absolutely.
and categorically directed you to file the supplementary affidavit what the rate you have approved.
Yes, absolutely. That should have been done. But
You
kindly
can
keep,
take your own decision.
kindly keep both the matters on. But kindly take only one. Writ petition. Just to give you lots of glimpse of what is being done. My lord,
Yes.
my lord, kindly take the rate which was first. At the first column, it has been.
Page 9.
Page 9 of the writ petition.
I am challenging separately, kindly don't go.
Say that you talk about the rate chart.
Certainly not, I see.
Yes.
So
So what? Garbage challenge the rate that we are actually trying to solve the tender process. No, kindly come to internal page 9. Yes. Kindly come to internal page. Not the rate which is for diabetes. Now it has been. Rate which was lunch. Which was.
That will come.
Happy with that.
You come with all the
Look,
things.
we'll come back on Tuesday. The law officers are present.
When
Supplement.
the matter is that matter.
That matter is on 24th August. Kindly.
20th August, let come.
But,
20th at what PM? 2 PM. A fixed matter. 20th August, it is a fixed matter. Then come on 20th. You serve the copy in advance. You serve the copy. They wanted to take the exception. They will take the exception. I will take.
From 1st of August, they will benefit.
Why? Let the court ascertain.
Now, effect of this is.
So what
But the-
what would the effect of the order passed by
But I told you.
directing you to file?
Installed Well, let us come back on Tuesday. The affidavit, what we were trying.
I know,
We are
but
proceeding.
earlier government, this
Kindly-
court is not concerned with the
Can
government.
we allow us
This
to?
court is only concerned with the law. If
But
you
we
comply
have-
the law, the court is,
we have-
you have not,
But I was.
is against.
I was.
Don't say this government, that government.
No, not like that. Thank you, sir, Tuesday. Installed.
There are matters 20,
Let the process will install. I tell you, what's
let me stop. You have created the problem.
But the entire process.
Instead of taking the decision for publishing, kindly read the order, read my order.
Kindly comes, look. Kindly comes. Your lordship has never stopped us from proceeding with the first tender.
Why the supplementary affidavit?
Kindly take that order.
But already in that case, the stay is there. So what further stay is
But
required?
that was for the earlier tender.
Maybe, so now you wanted to fresh tender.
His case was there is no rate check. We have prepared it.
This court find that the analogous matter is fixed on 22nd of August
20th
2020.
of August.
20th August?
20th August.
20 August 2026.
But he has not
Yeah.
paid for his.
This specific matter, let this petition be placed
My lord.
before this court on the said day. In the meantime, responding authorities are directed not to implement. Whether tender notice is issued.
But in kind of.
Some tender, some.
Challenge it. You are not checking. See what happens.
Rate check should
Yes.
give level to that.
Can you come to the prayers?
Not challenge.
Can you come to the prayers? Can you come to the prayers?
Any effect or not to give any effect or further effect to the circular dated 23rd of July 2026
But that's not a challenge.
till 22nd or till 20th of August 2020.
That's not challenging the petition. But can you look at the prayers?
Yes, next.
Strong ones. But that's not challenging the petition.
My lord, in item number 3, if your lordship kindly permit me to appear through online, because
I am for this.
now,
Yes.
my lord, if your lordship kindly straightway come to page 100 of your lordship's order. But kindly remember the railway authority, now my lord, while floating the tender, insisted upon the successful bidder to purchase the goods from particular 3%. Now, my lord, if your lordship kindly straightway come to page 100.
That is your lordship order, matter. That is.
But my difficulty is that one of my relative is in hospital, my lord. If your lordship permit me, I am doing the matter from the hospital, my lord. That's why, my lord, I could not open the camera, my lord. If your lordship kindly pardon me, my lord.
Sir,
Yes.
you are in the hospital and from hospital you be allowed to, without any gown and without any coat, you are in the hospital and you will be
No, my,
allowed.
I have the coat.
And from the hospital, that's a way to, and why, where is appearance?
But kindly pardon me, then, my lord, I am leaving, my lord.
May I take over?
The petition is not
May I
present.
take over? Not,
You are
may I-
petitioner.
May I take over? May I take?
He
Kindly,
is telling that he is appearing.
kindly, he's leading. He was leading. My lord, kindly, my lord, do not, my lord, take us amiss. Lord, some problems happen, my lord.
Yes.
Now, this pertains to, my lord, the similar matter. Your lordship has passed an order in the same matter.
Hmm.
Kindly comes to page 100. Lord, 3 foreign companies, Lord, in the name of Make in India, comes and participates, and Lord, they have been, Lord, tenders have been floated as if Lord, materials only from them have to be Lord, taken. Lord, kindly comes to page 100. In the similar writ petition, Lord, same writ petitioner. The petition has a file such and such. Your lordship would see, Lord, learned counsel submits that for the manufacturer, second paragraph, Lord, TDPCP. Lord, this is the component. But the responding authorities have only chosen to accept tendering Comerling, Aluplast and Alstone. Lord, these are the only 3 companies again in this tender also, Lord, this TDCP or not TDPCP. Lord, that component again has been Lord directed to be taken from them. Lord, kindly, I'll take your lordship and then Lord kindly turns over to page 101, paragraph number 6. The lordship was kind enough, Lord, to pass an interim order to that effect. This writ petition, Lord, came up before your lordship yesterday also.
Yes.
Lord, we had taken out an application for Can 2, Lord, alleging the same dispute. Your lordship wanted us, my lord, to come back with, my lord, a fresh writ petition because definitely.
What has
my lord,
happened to this writ petition?
Yes, my lord, here. my lord,
Now, what has happened to this writ petition? It is pending.
Yes, just
That is pending, my lord. Point is that, my lord,
affidavits.
that
have
is
been
make in India or make out India, my lord. That government policy is that, my lord. Some cabinet secretary decision has been taken into consideration that every goods has been manufactured after COVID, my lord, in India, my lord. That petitioner allegation is that only outsider only taking into advantage this project, my lord. But actually, according to my, just I got the brief, just not 5 minutes ago.
Where is the notification?
That is, my lord,
Made in
notification.
India?
Make it,
No,
make
that
it in
your
India,
lordship
my
would
lord.
find, my lord, kindly comes to page 23. First 23, then, my lord, I'll take your lordship to 30.
Yes, page 23, my lord. That is.
Public procurement preference to make in India, whereas is the policy of the such and such to encourage make in India and promote manufacturing production of goods and services in India with a view to enhancing income and employment. No, these were the reasons. Kindly, not straight away comes to page 30 then.
No, but the reference
Fine.
purpose of local contents means the amount excluding net domestic. Yes, then
Yes. Now, not kindly comes to page 30. Here, my lord, the railway board issues a circular indicated or my lord memo indicating the Ministry of Commerce and Department Search and Promotion in my paragraph number 1. In compliance with rule 153 of the General Financial Rules has
from your
issued,
where from your reading?
not page 30.
That's
type
the
copy,
English,
lord.
English version, my lord.
Page 30, the type copy. That's the English version. Lordship, kindly got it, not?
Yes.
Yes. Now, paragraph number 1. The Ministry of Commerce and Industry, Department of Industrial Policy and Promotion, in compliance with Rule 153 of the General Financial Rules, has issued public procurement order, not the one I had just shown to your lordship.
Reference to make
This
in
order, I'm sorry.
Yes, reference to make in India order.
Yes. So, my lord, the reference is there.
Hmm.
Your lordship finds the railway board acknowledges that.
Correct.
Kindly, my lord, thereafter comes to page 23. I'm sorry, my lord, 33.
30?
33. The letter issued by the Cabinet Secretary dated, my lord, 5th of August 2021.
Yes.
Kindly, my lord, considers the last, my lord, paragraph. In view of the above, you are requested to advise all the procuring entities under your ministry department to ensure full compliance of not that 2017 letter and spirit. You are also requested to kindly review the implementation of the order and take all necessary measures, corrective actions so as to no deviation from that order takes place. So, my lord, this is thus where we stand today. Now, my lord, kindly now comes to page 105. This is not the impugned tender before your lordship.
Yes.
Lord, dear lordship, tender uploading time 9/7. Lord, this is the date. And Lord, bidding starts. Your lordship finds 17th of July. And today, Lord, is the closing date. Tender closing date, your lordship would find, Lord,
30th July.
31st of July. Your lordship has seen? Yes. Now, my lord, here, your lordship would find
Where is
the same names are there appearing.
Yeah.
Page, my lord, 105. Your lordship sees, my lord, item number 1.
Yes.
Description, walls area,
Supply.
supply such as to make Komalling, Aluplast, Alstom. The same companies. Lord, one tender your lordship has stopped. They are floating the other tender, not so that it can be
That
done
is
in a
not the
circuitous
correct
manner.
version, my lord. According to my, বলেছো তুমি? হয়েছে?
No, no, এখনো শেষ করি।
Yes.
So the same thing. Now, my lord, your lordship has seen these names. On the same basis, same premise, your lordship was pleased to pass, not grant an interim order in the other writ petition, page 100. And that is still subsisting. They are yet to, my lord, file their opposition and response.
Yes.
Well, according to this petition, my lord,
and also previous matter, my lord. They are misrepresenting the act, my lord.
Correct.
What happened, my lord? Make in India. If, my lord, any France technology, ammunition, make in India, that is the policy. It may be outside company, it may be inside company. You know, she kindly come to
Outside
my lord.
company, inside. Whether these three companies are having their establishment factory in India.
Yes,
they are
my lord.
making in
That is
Show
my
me.
argument, my lord. I just got that.
If these three companies are having
Yes,
their
ma'am.
factories
Yes, ma'am.
in India, they are making in India.
You know, she
That-
kindly come to my lord page, their cost title, my lord. Page 2, my lord.
Yes.
Respondent 6, my lord. Commonly in having global headquarter eto. Add, my lord, through service in India head office.
Head
fifth floor,
office.
Koilas building.
Head
office,
office,
my lord.
Head office, where is the
Head
factory?
office means, my lord.
You do one thing.
Yes, my lord.
When the other matter is fixed.
No, the other matter is fixed.
After 4 weeks, a long time.
4 weeks.
Correct.
Lord,
You
18th
do one
September.
thing. You come with the report.
Yes, sir.
Come with
Next
the
week,
report.
my lord, I will.
Come with the report
Yes,
that they are having.
Yes,
They
ma'am.
are having
Yes,
the factories in the. They are manufacturing the product
Yes, ma'am.
in India.
Yes, ma'am.
Having their manufacturing factory. in
Yes, I
India.
will.
Bring the
Yes, my lord.
document.
Yes,
Then your submission, because make in India means it is in
Yes, sir.
India.
Make in- yes,
Whether
yes.
it is the foreign country or in India.
That is the policy of the government.
Yes,
Yes,
that's
ma'am.
I appreciate. So what then you will not proceed the tender process today, because today is the 2
The
p.m.
tender process may be going on
Not to
because
finalize.
this is the
But they
public,
will not allow to
not
participate.
finalized. Yes, my lord. That is
But they are not allowing to participate. How
that is their contention, my lord. Because, my lord.
No, if tomorrow
Yes, my
I
lord.
will allow you to continue the process.
Yes, my lord.
Correct.
Yes,
And
ma'am.
tomorrow, if it is found that they are not having the manufacturing factory in India
Yes, ma'am.
and they are not making in India,
Yes, my lord.
so if they will debug, then how
You
they
have to
will?
kindly no, pass the order that condition, my lord.
What?
That if my lord not, my lord, then my lord.
Let you lay a hand for the 1 week
Yes, my lord.
when you file the report.
Next Friday, my lord.
Huh?
Next Friday, my lord.
Friday.
Next Friday.
7th.
Yes,
7th August.
7th.
The petitioner has filed
Lord,
the patent application.
May I, Lord, may I only indicate one thing? Lord, again, Lord, this same thing happened on the previous occasion. Lord, based on the order, Lord, kindly comes to, this is the main problem, page 34. Kindly, Lord, comes to page 34. Because if this 34 continues, Lord, these kind of repeated tenders will keep on coming.
Let come.
Not
Let
beneficial for us, but
One-
they definitely
That
will-
is same company, my lord, similar.
kindly, Lord,
Yes,
stays
Father.
this section, page 34.
Let you are the thunder. Let they go. Let they come the report.
Yes, my lord.
Wait.
The petition has filed the present date application challenging the e-tender process dated e-tender process e-tender number LRC-3 underscore CT underscore LHB underscore NAC-RSP-R3
ওই একই company আর
R3
তিনটে হবে।
R3 wherein with respect of upgradation of toilet in LHB non-AC coaches. Counsel for the petition submit that the respondent authorities have allowed only three firms, namely on three firms, namely Comerling / Aluplast / Alstone to participate in the said tender. He submits that the said tender notice issued by the respondent authorities are in violation of is in violation of the Government of India Ministry of Railway Board Circular date number 2015/RS within bracket capital G /779/5 dated 3rd of August 2025, wherein the government has issued a direction for public procurement with the preference to make in India, Order 2017. The counsel for the petition further referred the order dated, circular dated 5th of August 2021 wherein the authorities have taken an appropriate decision requesting to advise all the procuring entities under the ministry department to ensure full compliance of PPP-M11 Order 2017 in letter and spirit. Full stop. Land Council, by referring the said two circulars, submit that it is the respondent authorities have to give preference to make in India. But the present tender notice has been issued by allowing the three firms to participate in the said tender, and the said companies are not manufacturing the product make in India. He further submit that on the earlier occasion also the respondent authorities have issued similar type of the tender, and the petitioners have challenged the same in WPA number 12777 of 2026 within bracket Tetronics Solutions LLP and another versus Union of India and others. And this court, by an order dated 12th of June 2026, has passed an interim order restraining the authorities to proceed with the said tender. Land Council for the respondent authorities submit that the petitioners are misinterpreting the circular dated of 2017 as well as the circular dated 5th of August 2021. He submits that the said three firms are also making the products in India, and as such the authorities have allowed the three firms. It is not that the said firms though are the foreign nationals but not making the product in India. He submit that he will place the document before this court to satisfy that the said three firms are manufacturing the products in India. Considering the influence, Land Council for the respondents prays for a week time to produce the file report with supporting documents to prove that the said three firms having the manufacturing unit in India and manufacturing the products in India. Full stop. Considering the submission made by the council for the respective parties, let the matter appear on 7th or 10th.
10th, because of Saturday, Sunday.
Then I am fixing on 11th.
Yes,
Fixed on 11th
No
of
problem.
August 2026 under the same heading within 10 matters. In the meantime, the respondent authorities are Land Council for the petition submit that today is the last date of submission of the tender at 2 p.m. and if the respondent authorities were allowed to continue with the tender process, if the petitioner will success in the present date application, they will not be in a position to participate in the said tender. In view of the above, the respondent authorities are directed not to proceed with the said tender process till 12th of August 2026 or until further order, whichever is earlier. List the matter on 11th at 11 under the same heading within 10 matters. For affidavit of service capital. Next.
The item 4, Milord, I am appearing for the petition as with Mr. Soumya Dasgupta.
Yes.
My lord, will kindly turn to page 30.
My lord, may I take, my lord, a preliminary objection, my lord? I have nothing to, but kindly consider, my lord, the petition once. My lord, kindly come to page 17, paragraph 40.
Page 17.
17.
Yes.
Paragraph 17, page 40, and my lord, the
Annex 7, page
44.
Yes, para 40.
Paragraph 40, page 17.
Yes.
And my lord, the order is at page 44. My lord, they know, my lord, I think the proper course is, my lord, it's entirely for them to decide, but
44.
No, I will not, sorry, will not, I missed this point. I accept his submission, will let this petition also be placed before the, will not, the other bench where, will not, this order was passed. I'm sorry. I think that's the correct point taken on Advocate General. That should be placed, will not, before that bench. I don't know how could anyway, I don't want to make any comment. Kindly go to that. Thank you, Mr. Advocate General.
But I will record your name. You will be compensated with the recording your name in.
It's the only way it can be compensated.
Nothing else.
Lordship.
So, but it is this is a single bench and that is a division bench. How? So they have to. I am giving liberty to withdraw and file a press writ application.
No, these poor people, they will suffer, but let it be placed before the appropriate bench.
Okay. That's
it should go before that. That would do.
The Advocate General has raised the point of maintainability by referring paragraph 40 of the writ application, wherein the petitioner admitted that a public interest litigation being WPA within bracket P number 321 of 2026 within bracket Sirsanya Bandopadhyay versus the state of West Bengal and others is pending before the Honorable Division Bench. The Advocate General also referred to the order passed by the Honorable Division Bench dated 8th of July 2026. Mr. Vikas Ranjan Bhattacharya, learned senior advocate appearing for the petitioner, concede that the matter has to go to go before the Honorable Division Bench where the public interest litigation is taken up for hearing. In view of the above. Consider the submission made by the counsel for the respective parties and considering the rule 15 of the writ rules of the appellate's writ rules, the writ petition is released from this court with the direction to the registry to place before the Honorable Division Bench wherein WPA number, Honorable Division Bench wherein the WPA number, WPA V 321 of 2026 within bracket Sirsanya Bandopadhyay versus State of Bengal is pending. Thank you. Thank you to assist the court for Rule 15. ऊपर হবে affidavit of service capital. Yes.
I appear for the petitioner.
Yes.
It's on the last occasion, time was sought for the other side. Both the petitioners are senior citizens. My lord will straight away come to.
Is a prayer.
My prayer is one of execution of the order of maintenance. Now, my lords, page 42, if my lord kindly takes up. Page
42.
Page 42 of my writ petition.
Order passed by the tribunal.
My lord, kindly the last paragraph.
Page 45. 42.
42, my lord. The third paragraph, my lord, if my lord kindly takes up.
The OP, that is the Bapi Giri, is directed
to just the third paragraph, beg your pardon. Third paragraph. In the meantime, as reported by the BDO, the OP has installed CCTVs.
Where from you reading?
Page 42, the third paragraph.
Okay.
The third paragraph, my lord. In the meantime, has my lord got it? In the meantime, as reported by the BDO, the OP has installed CCTVs at the concerned house in question, thereby again vindicating his sound financial resourcefulness. Then, my lord, kindly comes to the second para of that page. The OP, that is Bapigiri, is directed to pay rupees 7,000 per month as maintenance allowance as per the provisions laid down in 9.2 of the Maintenance and Welfare of Parents and Senior Citizens Act directed to bank account such and such, my lords. This was the primary order passed by the BDO, the officiating tribunal. Thereafter, my lord, kindly come. Thereafter, we sought for an enhancement. That order of the DM, my lord, will get at page number 50. Lord, kindly comes to page 50. My lord, page
Yes.
50, my lord, fourth paragraph. Thus, considering the financial well-being, has my lord got it? Thus, considering the financial well-being of OP Bapigiri as well as advancing age of the appellant, it is hereby ordered that as per 9(2) of the Act, the amount of maintenance is enhanced to rupees 10,000. Then thereafter,
When it was announced 25.
first was 7,000, now it is 10,000.
No, the first order is what is ordered at 23.
The first
And he
order
has to
is
pay by August, from August 2023.
2023,
From August
my lords.
2023. And this order was September 2025.
Grateful, my lord. Yes.
Yes. Then
Thereafter, my lord, kindly comes to page 52, where we have filed an execution application. Page 52,
yes.
where the execution application is there. My lord, this has not been taken up for hearing. We have preferred a representation thereafter also, stating that kindly takes this up for hearing. That is at page 60.
So this is pending before the authority.
This is pending before the authority, my lords. Now, my lords, from 2023, they have not paid a single penny.
You are the son or not?
Lordship, I am this not
Yes.
only son. Lordship, there is another son.
Hmm.
Who is also,
Have you challenged the order? Have you?
the application was preferred, Lordship. Subsequently, it was preferred since the learned advocate appear, and a restoration application therefore is pending, Lordship.
Which court?
Lordship,
Which court it is pending?
Lordship, that's not in the list, Lordship, but the restoration application has been already filed.
So which court it will go?
Lordship, that is not the application is not.
What application you filed? Recalling? Restoration of your writ petition? So whatever it may be, till date there is no stay.
No payment.
No,
Correct. There is no stay, and order passed in 2023. So on August 2023 to August 2025, 2 years per month 7,000, and September 2025 till date 10,000.
With subject to correction.
Private respondent out of work, Lordship.
Ah.
In his household, he has two children and wife. The household is running.
Video
by his
report says
brother-in-law.
otherwise.
He has medical issues also. Lordship.
Kindly comes to page 41, my lord. 41. 41, my lord.
Yes, I will come to you. Yes.
At present, it is not that he is avoiding it on his own choice, Lordship. Since 2021, after the COVID situation, the financial situation is very much poor. He worked as a labor contractor. Now he is out of work, Lordship. That is why he couldn't pay at this moment, Lordship. Even he couldn't follow through the lead application. That is why the applications also got dismissed for default, Lordship.
Okay. Well, it's page 41.
Yeah, how
kindly comes 41.
Lordship
41.
arose from the property dispute.
Page 41, my lord, second paragraph.
The property undivided, the portion of the petitioners,
Second paragraph.
already. And the house now they are living, that was constructed by this private respondent, and the land property was from the paternal uncle and the aunt. But the main problem is the property is undivided, Lordship. That is the sole issue, whole situation, Lordship.
Lord, may I
since
please?
the 2021, this financial situation is not right, Lordship. That's why they started now demanding them to hand over the property, the house, where at present the petitioners are living.
Lord, page 41, my lord.
Another son also who is looking after them, Lordship. They have their own share of property. It is not that I am avoiding it on of my own.
Where
choice.
you are residing?
Lordship, at present,
Where you are residing?
the Andaman Nicobar, where
He has a house of his own.
Just
No,
a
no,
minute.
no.
Just a minute. Yes.
I have no house, no property, Lordship. They are used to work as labor contractor.
Hmm.
His family is also there. Lordship.
Labor contractor
Used
in
to.
Andaman.
Definitely.
Used to.
Definitely.
Used to. After 2021, he has no work or he is off and on in his work. Sometimes.
What work? Andaman own work. What he is doing in Andaman own work?
Lordship, labor work.
What labor work? Well, you know the Andaman in labor. What is that per day? Per day the minimum wage in Andaman. You know. If you are the labor contractor, now you are doing the labor work.
Lordship,
Then it is digestible. Okay.
continuously
You give the address in Andaman. Which place I will bring him tomorrow. Day after tomorrow, Monday I will bring him from Andaman. No problem.
Well, kindly takes up page.
Which place you
41 once,
give the
well,
address?
Sir, submissions devoid of.
the address.
What is the address in Andaman? I will bring him here. Here you know. And this could also
Page
will ascertain
41,
whether it is a
contrary to
labor
what he is
contractor,
submission.
whether he is a labor, or whether he is having his own house, or whether he is doing conducting the tourist business over there.
Well, page 41 is absolutely contrary to what he's submitting. This is a report of the BDO.
You tell me whether your client will pay or not, then I have to pass on.
That is
Only one thing. I am asking only one question. Tell me your client will pay, and when we will pay, then I will fix the date.
I have asked him.
I will refer the matter to the tribunal and directing you to appear before the tribunal. And if you will not appear before the tribunal,
and coercive steps may be taken. He's taken the
tell me,
tribunal
give the
for a
date.
ride.
That's why I am giving one opportunity to give the date when you will appear before the tribunal.
Well, I kindly keeps the read pending. He's taken the tribunal for a ride. Is he using his local influence there?
When you will appear before the tribunal, tell me.
If I may read page 41, my lord.
Yes, I have gone through.
Okay. Grateful. My lord, as per our calculations, 2,92,000 is pending. That is 7,000 and 10,000. Yes. As on July 2026, 2,92,000 is pending. Not a single penny paid.
2 months time.
The 2 months is
2 months.
2 months.
2 hours journey. And 1 hour from here to which area? Which SDO?
SDO Canning.
Canning. Not even 2 hours. Calcutta to airport to Canning, there's minimum 2 hours, and Andaman to Kolkata 2 hours. 4 hours. I will give this 48 hours. Or I will give the 72 hours. You come on 72 hours. The petitioner has filed the present application, praying for the direction upon the tribunal for expedite hearing of the application filed by the petitioner for enforcement of the order passed by the learned tribunal, that is Sub-Divisional Officer Canning, dated 28th of July 2023, as well as the Appellate Authority, dated 18th of September 2025. The petitioners are the senior citizens and are the mother and father of the private respondent. The petitioners have made an application before the learned tribunal for grant of maintenance. Accordingly, by an order dated 28th of July 2023, the learned tribunal passed an order directing the respondent number 6 to pay rupees 7,000 per month as maintenance allowance as per the provisions laid down under section 9 within bracket 2 of the Maintenance and Welfare of Payment and Welfare of Parents and Senior Citizen Act 2007. The tribunal has directed the respondent number 6 to directly transfer the account either of the parents within 10 of every month starting from August 2020. The petitioner being agreed with the said order have preferred an appeal before the appellate tribunal. And the appellate tribunal by an order dated 18th of September 2025 has modified the order by directing the respondent number 6 to pay the maintenance amount of rupees 10,000 per month instead of rupees 7,000 as directed by the tribunal. After the order passed by the appellate tribunal, the petitioner has preferred an application for execution of the order as the respondent number 6 failed to pay the amount as directed by the tribunal as well as the appellate tribunal. In spite of filing the application for enforcement of the order of maintenance, the learned tribunal has not taken any steps. Though the petitioner has made several representations to the tribunal for considering the application filed by the petitioner for enforcement of the order. Learned counsel appearing for the respondent number 6 submits that the respondent number 6 is residing in Andaman and he requires some time to appear before the tribunal. He further submits that the private respondent has filed a writ application challenging the order passed by the tribunal, but the writ petition was dismissed for default, and the private respondent filed an application for recalling of the order of dismissal, but the same is pending before the court. Had the learned counsel for the respective parties peruse the materials on record. Admittedly, the learned tribunal has passed an order on 28th of July 2023, wherein the opposite party was directed to pay rupees 7,000 from the month of August 2023. Subsequently, the order was modified by the appellate authority by an order dated 18th of September 2025. Admittedly, the private respondent has not paid any amount as directed by the tribunal or by the appellate tribunal. Considering the above, the tribunal is directed to expedite the application filed by the petitioner for enforcement of the order dated 28th of July 2023 as well as the 18th of September 2025 as early as possible and to dispose of the same within a period of 2 months from the date of receipt of this order. Full stop. It is the private respondent is directed to as 2 months as expeditious as possible. Full stop. The private respondent is directed to appear before the tribunal on on 12th of August 2023.
And coercive steps to be taken if he does not appear. Kindly record.
2026. It is made clear that if the private respondent failed to appear before the tribunal on 12th of August 2026, the tribunal shall take appropriate steps for assuring the appearance of the private respondent before the tribunal for execution of the order dated 23rd of July 2020. And the order passed by the appellate tribunal.
Kindly still read pending.
The petition is disposed of. Yes, next.
Grateful.
The 6 not on the last occasion they are supposed to take instruction whether they will approach the criminal court. Regarding
Mitra was arguing this matter yesterday.
Yes.
Just instructions. I think we've taken, my lord. We were trying to convince your lordship that perhaps an order could be made as prayed for without seeking instructions from the criminal court in this writ itself. These 2 short points I'm told, my lord, were urged on their behalf. One is the single bench decision of the Delhi High Court, and the other point which perhaps helped from your lordship was that the viris has not been challenged. Viris of the notification has not been challenged.
the virus is contained earlier than round of litigation. The virus was challenged, but it was held that it is an intravirus. There is no ultra.
Yes. So, grateful, Malad. So here we are not challenging virus also. We are on interpretation of the particular notification. We don't need to challenge virus anyway, Malad, because there's a piece of delegated legislation.
Correct.
The parent legislation is intra-virus, the constitution that is separate. But delegated legislation, one need not challenge the virus. Malad, our respectful submission was, Malad, that the interpretation of this has been done by the Honorable Delhi High Court in that division bench judgment, which your Lordship has, Mr. Mitra has placed yesterday. The division bench judgment of Delhi High Court, 2026, Raj Gopal.
Yes, Rajgopal Chakravarti.
Yes. So, Malad, this division bench decision, if I may trouble your Lordship with, Malad, conclusively interprets this after considering Mahesh Agarwal.
Yes.
May I just place the relevant paragraphs on space, Malad?
Page 31. Can you come to the paragraph 31 of the Delhi High Court?
Yes.
Again, left over to the passport authority. There is no direction, then the passport authority can kindly come to the paragraph 31 of the Delhi High Court Rajgopal order.
Yes. Kindly have, Malad. In view of the foregoing, it is not mandatory for the court. That is one of the trial court. The
Correct.
criminal court, it is not mandatory for the criminal court to specify the duration of since the notification cannot override, where the court has not imposed any restriction in regard to the duration for renewal of the passport. Passport authority is obliged to consider the application for renewal in accordance with law and in own merits, and the period of validity shall be governed by the act and the rules. That is all that it says, Malad. Now, Malad, kindly see one. Then 34, please, Malad.
Yes.
In view of the above, the decision in Mahesh Kumar Agarwal does not lay down that in the absence of a court-specified period, the passport authority is denuded of the power to renew a passport for a period exceeding 1 year.
Correct.
Passport authority has the power. The legal position as enunciated in Kaushalya Devi is unequivocal that where the court has not specified any duration, that is the criminal court, the renewal of the passport must be considered strictly in accordance with the provision of the acts and the rules. The impugned order likewise proceeds on the basis of law laid down and correctly holds that the renewal respondent's passport is liable to be renewed in accordance with law without insisting upon any court-specified period of validity, and therefore the impugned order correctly reiterates the position on law and warrants no interference. So, Malad, that is what Delhi High Court says. You cannot insist. Now, Malad, when they bring in this 1 year, they have to give reasons. If your Lordship kindly sees the order where they have communicated this period of 1 year, whether this 2118, kindly see, Malad.
Yes, 216.
216, I'm so sorry. The matter has been examined in the light of the relevant sections of the Act, the Gazette notification, and the judgment dated so-and-so passed by the Honorable Supreme Court in the matter of Mahesh Agarwal. In accordance with the condition laid down in A2 of the Gazette notification, a passport with 1 year validity can be issued to you based on the order dated so-and-so, passed by the learned so-and-so. Now, kindly see, Malad, the reasoning given is based on the order dated 13th October 2025. And, Malad, A2 is attracted. A2 is order dated 13th October 2025 does not give a period. Kindly see the order once, please, Malad.
No, first you come to the A2218. 218, if no period either for issuing the passport or for the travel abroad
Yes.
is specified in such order, passport shall be issued for the 1 year.
Yes.
Correct. That's why, and kindly come to the magistrate order, the trial court order, sorry.
13th October 20.
13th October. That is page number 205.
Yes.
205.
9th October and 13th October. 13th October, your Lordship will have at 206.
206, yes. 206, 13th October. So the court has only indemnity of rupees 10 lakhs of original paper is property equivalent. The court has not passed any order.
And to surrender the passport within 5 days from the renewal. Passport has to be surrendered because there's a travel permission is restricted only upon permission of the court. The travel can take place even if the passport is renewed. That is the order of the Honorable Court. Now, so then, my lord, they say that A2 is based on the order dated so-and-so because no time is given. We are giving a 1 year time. This is what the Delhi High Court says, my lord, is not correct, my lord. Does not denude. does not denude.
I appreciate.
Yes,
Delhi
that is-
also stated that no court cannot, you cannot force the court to give the time.
Yes.
Correct. And but the authority, if the authority will say 1 year, 2 years, so what is your right? Well, so with the act, in the Passport Act, the minimum for a period of 5 years, minimum for a period of 2 years.
Rule 12.
If-
Kindly have the rules once, please, my lord. Rules under the Passport Act. Rule 12. Copy दिए चुके
अरे यहाँ रखने से कल तो यहाँ था, कहाँ चले जाता?
Pass. May I hand?
Rule?
Rule 12. One, your lordship, kindly.
Just a minute. Let me check.
An ordinary I'm sorry. उसमें है? है rules है? Yes.
Page 28 of the book.
28 section. Yes, yes. Rule 12, duration of passport.
Yes, please, my lord.
Yes.
An ordinary passport for persons other than children below the age of 15 years containing 36 pages shall be in force for a period of 10 years from the date of its issue. So
Shall
the-
be.
Shall be. So it's mandatory. The alternative is only whether 36 pages or 60 pages. That is the only alternative. But shall be 10. If he's a well-traveled person, my lord, then they give 60 pages, like Mr. Mitro, my lord. If they get 60 pages, I get 36 pages.
Mr. Mitra always 32 pages.
I don't require. Now Schengen is one visa which covers.
The stamp is required. Stamp is required.
You have to be in the queue.
Yes. So Mr. Mitra 60 pages, and for me 36 pages. But 10 years is fixed. That is why we say, man, that is what all that I'm trying to tell you, Lordship. The Delhi High Court is saying you're not denuded of the power. You have to independently
That's right.
assess.
Yes.
And my lord, that okay, if your Lordship kindly permits. I'm so sorry.
Two more principles here I want to address, my lord. One is that my learned friend rightly pointed out that we have not challenged the vires of 9-2. So his lordship knows. I don't need to tell you the vires. That is the judgment of the Supreme Court is there. And my lord, the Central Act. This is after all central notification. This is a Central Act. Rule 12. There is a judgment of the Delhi High Court, and the law is the same. So, my lord, whether the interpretation by them can be different in Bengal and different in Delhi. Also, I've got other judgments, Madras giving 10 years in spite of this rule 2, even if the criminal proceedings are pending.
No, that's why they are giving if the magistrate or the trial court grants that.
No.
They are giving.
It is just the reverse. What they are doing is, if the magistrate does not give time, does not say how many years, but says, I'm giving you a passport back for a renewal. But when you get it renewed, you can't travel without the permission. Now, where the court says it's an unlimited renewal, but the court doesn't say renewal for how many years. That is what the Supreme Court has said, and also the Delhi High Court, that you cannot say fixing so many years renewal, because that is the power of the competent authority under the Passports Act. So, but when that is so, then rule for A2 cannot impinge upon rule 12. Notification A2 can't impinge upon rule 12. Lordship kindly takes a look at the Delhi High Court judgment, division bench.
Yes.
Lordship, this cautionability which my lord only was noting, pointed out. Lordship, that is the whole logic. Lordship, kindly see para 31.
Yes. Yesterday.
Lordship has seen it. Lordship, I will just give my iPad down also. iPad. Kushuvingas, Kushuvingas is, yes, that is of course, Lordship knows that.
Yes, that is referred paragraph 30 of the Kausalya. This in the Delhi High Court.
Yes, Delhi High Court, no.
Delhi High Court referred the Kausalya.
Lordship, Kushuvingas, Lordship, paragraph 22, just for the records, paragraph 22 of Kushuvingas, দিয়ে দাও 22 আর অন্যরা 16 টা দিয়ে দাও 16 টা দেখি 16 টা ওই আমার আরে কপি আছে 16.3 হ্যাঁ দিয়ে দাও The court must have requisite territorial jurisdiction. An order passed on a writ petition questioning the constitutionality of a parliamentary act, whether interim or final, keeping in view the provisions contained in 226.2, have effect throughout the territory of India. I mean, of course, the applicability. So this is the Delhi High Court is throughout the territory of India. So they can't contend to the contrary unless they can get it reversed by the Supreme Court. Worship takes us a look at 16.3 SCC, paragraph 29. These are all very, very settled principles of law, which I what I've showed, paragraph 29 of 16.3 SCC. This is because this notification goes beyond the rules. Paragraph 29. It would be seen that Sri Agarwal is on firm ground because this court has specifically stated that rules or regulations which are in the nature of subordinate legislation, which are ultra vires, are bound to be ignored by the courts when the question of the enforcement arises, and the mere fact that there is no specific relief sought for to strike down or declare them ultra vires would stand in the way, courts basically ignoring them. As for Delhi High Court also,
yes.
Worship, Madras is doing the same thing. Worship, I will just Karti Chidambaram's case. Karti Chidambaram, Worship, copy is not there. May I hand up my copy?
What is the citation?
That is not, that's again an unreported judgment. Well, may I hand up to my lord?
You will get in the SCC. Okay,
yes. Then,
Anupata is there. Yes.
Karti Chidambaram, Lordship kindly takes a look at, not directly on the point, but Lordship sees paragraph 87 onwards, the last year says. Dara bolche abhi tomar, Dara bolche. সবই জানো তো না এটা 1190
yes
paragraph Lordship here, Lordship towards the end, Lordship kindly come to operative part, last page, paragraph 84. In this case we are concerned, para 84 last page, we are concerned with the curtailment of period of passport which is permissible in terms of section 7 upon reasons to be communicated in writing to the applicant. A query was put by the court as to whether the writ petition was premature, as no order had been passed on the application of the petitioner seeking extension for the full period of 10 years. The Sundaresh orally as well as the counter in writing confirmed the apprehension petition to the effect that though the passport was intended to be issued, it would have contained only a shorter validity period of 1 year. The counter at paragraph 12 confirms this position. That was the standard. Furthermore, only 1 year short validity may be issued to the applicant as per A2. That's what they are. Unless the court orders specifies a period for which passport has to be issued. There is thus no purpose to be served in directing the respondent to dispose the petitioner's application, as the result of such a direction is a foregone conclusion. Section 7B permits the issuance of a shorter validity passport only in the event reasons have been assigned for such issuance. The counter does not set out any reasons at all for such curtailment, and there is no elaboration of this. Para 87, though the pendency of the criminal cases is admitted, the petitioner has approached the court several times in the interim seeking permission to travel. Such permission is seen to have been granted, and there's also a finding of the order, the judge to the effect that the petitioner has not breached any condition. Thus, and also for the reason that the proposal to limit the period is bereft of any reasoning. I see no impediment issuance for the period up to 10 years.
Reasoning is the same which is given here in our case. It's the same
Yes.
reasoning.
So, Malad, A2. So, Malad, since it's being followed in other states, we in Bengal shouldn't be having lesser liberty than than those in other states. This is all I say.
Your Lordship, kindly take Delhi High Court Division Bench.
No, when are you taken the determination of this court that I find the unheard of the lawyers with regard to this? Then I have started all this.
I was telling my junior, Mr. Thakkar, Andaman's matter, somebody having a guts to argue before my law. And I said, I had once in a while, I said, I don't think before my law. His lordship knows too much interior.
That's why telling the labor. Yes.
Now, normally, your Lordship knows, when a criminal case is pending, passport will not be issued. But there is a provision, Section 22 of the Passport Act gives the power to the central government to exempt. Now, in exercise of power under Section 22, this notification was issued. Now, challenging the virus of this notification, a writ petition was filed. Before this Honorable Court, kindly see the order passed by this Honorable Court. Now, your Lordship, the similar things arose, here the petitioner also paid for a passport for 10 years. And the virus of the notification issued by the Ministry of External Affairs, that is on GSR 570E, dated 25th of August 1993 was challenged. Now, your Lordship, kindly text paragraph 20 first.
Yes.
Yes, plus paragraph 20. Thus, the same provisions applicable to the issuance of passports apply to the grant of extension as well. Hence, the Section 7 and Section 8 empowers the passport authority to issue a passport for a shorter period than that the prescribed the normal circumstances as well. In his discussion, thus the clause A2 is entirely in consonance. Paragraph 20. In consonance with such power under Section 7 of the 1967 Act, as the grant of passport in exempted cases where the criminal proceeding is pending cannot be equated with the normal circumstances emphasized under Rule 12. Now, my lord, kindly skip certain paragraphs, my lord. Now turn to, my lord, paragraph 28. Hence, it is reiterated the clause A2 of the improved notification stands on sound legal and constitutional footing. Now, these are my argument, my lord, quoted by the learned judge. My lord, now, my lord, can you see, my lord, findings? The Karti Chidambaram was also considered, my lord, paragraph 34. Now, my lord, can you comes to the finding? Paragraph 38 onwards.
Yes.
Seen from such perspective, Section 6(2)(f) is a reasonable restriction imposed by the law within the framework of Article 19(5) of the Constitution and divorce the issuance of passport where the proceeding is in respect of an offence alleged to have been committed by the applicant is pending before the criminal court in India. Section 22 of the 1967 Act is an exception carved out from the restriction imposed by the Act itself. The said section confers on the central government the power to exempt where it is the opinion that it is necessary and expedient in the public interest to do so by notification in the official gazette, and such exemption by notification includes the exemption to any person or class of persons from the operation of or any of the provisions of the Act and the rules made thereunder. Thus, the improved notifications dated August 25, 1993 was issued by the central government under the power conferred on it by Section 22A, which is also reflected from the notification itself. Hence, we have to keep in mind the wider backdrop of Section 6(2)(f) in the parent provision which has been enacted by virtue of legislative power conferred on Section 19(5) of the Constitution of India. Section 22 of the Act provides an exception thereto, and thus it is a relaxation in favor of the category of the persons who are otherwise reasonably restrained from obtaining a passport within the confines of 6(2)(f). Hence, the very source of the power of the central government to publish the concerned notification is vested by Section 22 of the 1967 Act. Thus, repository of the power of exemption is not the court but the central government, flowing from Section 22 of the 1967 Act, which carves out an exception to restriction provided under Section 19(5) of the Constitution. Being such repository of power, the central government in its discussion has issued the impugn notification dated August 25, 1993, and in its power, the delegate legislation has stipulated the clause A2, where it is provided that if no period of permission to travel upload is provided in the court's order, the passport will be issued for a period of 1 year. Subclause 1 and 2 of clause A of the notification had been promulgated by the same authority which the central government, under its power of delegated legislations conferred by the same source, that is the section 22 of the 1967 Act. Thus, the two subclauses operate on parallel footing and cannot carve out the exceptions from each other. Now, can you text me paragraph 46? Similarly, where subsection 2 restricts the issuance of passport to 1 year, where the court does not specify any period, the central government deliberately retains with itself the power to stipulate the period of issuance of passport, where the court does not exercise such discretion. Such exercise of delegated legislation is perfectly within the confines of section 22 of the 1967 Act. The principle of wisdom of the legislation has primacy in respect of the legislative domain can be extended to delegated legislation exercised by the central government in publications of the notification in question under the aegis of section 22 of the 1967 Act. The matter can be looked into from another perspective as well. The discussion emphasized in subsection 2, subclause 2, can be viewed from two standpoints. One view can be the court chooses to grant inbuilt permissions to the applicant to leave the country, but not stipulating any time frame for such permission. The other equally valid view, however, is that the court chooses not to exercise the discretions conferred on subclause A by granting such permissions to depart from the country, but abstaining from stipulating the period therefore. Hence, the interpretation lends the central government to its own delegated legislative accepting the latter view cannot be faulted on the ground of unreasonableness and arbitrariness. It is well settled that the legislator or delegated legislations to be held the constitutional or contrary to the parent legislation. The high ground of unconstitutionality or irrationality has to be made out. The interference of the legislative wisdom, either in respect of the principal legislation or delegated legislation, requires such much higher test to be satisfied than in the case of executive action. The very concept of separation of power ingrained in Constitution of India is an inbuilt safeguard to enable the power being exercised by any of the three pillars of democracy. Now, next paragraph 50, accordingly, it cannot be construed. The central government, the exercise of power under section 22 of the 1967 Act, has chosen in its legislative instrument to delineate the two situations as escapulated in subsection subclause 1, 2 of clause A of the notification in issue. Now we'll kindly see paragraph 52. The argument on the premises of Rule 12 cannot be sustained since the rules framed under 1967 Act cannot override the notification which has been promulgated with the power conferred by section 22 of the parent act itself. That apart, as rightly argued by the Union of India, the Rule 12 contemplates the normal situation of the passport in India. Passport is sought by the ordinary citizen, not where there is a bar under section 6(2)(f) of the said act. So, this point has been elaborately described by learned single judge, and 6(2)(f), let us see 6(2)(f) once. Can you see what is the 6(2)(f)? 6(2)(f), section 6(2)(f). Now, page 9 of this book.
Page 9.
Page 9.
Yes.
Now, section 6(1) says, can you see section 6(1) says that subject to the other provisions of this act, the passport authority shall refuse to make an endorsement for visiting any foreign country under clause B and C of subsection 2 of section 5 or any of the more following grounds and no other grounds, namely. Now, these are the grounds. Now, can you see 6(2)? Subject to the provisions of the act, the passport authority shall refuse to issue the passport or travel document for visiting any foreign country under clause C of subsection 2 of section 5 on any or more of the following grounds and no other grounds, namely all these things. The applicant is not a citizen of India and all these things, like can you see 6(2)(f). The proceeding in respect of an offence alleged to have been committed by the applicant are pending before the criminal court in India. So, my lord, in normal circumstances, my lord, when a criminal case is pending against me, the passport will not be issued. Now, my lord, can I transfer section 21? Section 21 of this Passport Act, page 18. It says, my lord, power to delegate. The central government may, by notification in the official gazette, direct that any power or function which may be exercised or performed by it under this act or any other power under clause D of subsection 1 of section 6 or the power under clause 1 of subsection 2 of the section or the power under section 24 in relation to such matter and subject to such conditions, if any, as it may specify in the notification, be exercised or performed by such authority or authority subordinate to the central government, by any state government or by any officer or authority subordinate to such government, or in any foreign country in which there is a diplomatic mission of India by such foreign consular officer, as may be specified in the notification. Now, Miller section 22, kindly see, power to exempt. For the central government is of the opinion that it is necessary or expediently in the public interest so to so, it may by notification in the official gazette subject to such conditions, if any, as it may specify in the notification, exempt any person or class of persons from the operations of all or any of the provisions of this act and the rules made thereunder, and as often as may be cancel such notification and again subject by such like notification the person or class of persons to the operation of such provisions. So, my lord, section 22, my lord, empowers the central government, my lord, to issue the notification, and this GSR 570, my lord, dated, my lord, 25th of August 1993 was issued by exercising of power of, my lord, section 22. Now, my lord, can you see the GSR 571, page 20 of this book?
Yes.
Page 20, my lord, the GSR 570 is there. Yes. This is the notification. As you also got it. It says, my lord, the Ministry of External Affairs, notification number such and such, dated such and such, published in the Gazette of India, such and such. Now, I can see. In exercise of the power conferred by clause A of section 22 of the Passport Act 1967, and in superstition of the notification of the Government of India, in the Ministry of External Affairs, GSR number such and such, dated 14th of April 1976, the central government being of the opinion that it is necessary in public interest so to do so, hereby exempts citizen of India against whom in respect of an alleged offence have been proceedings in respect of an alleged offence to have been committed by them are pending before a court, the criminal court in India, and who produces order from the court concerned permitting them to depart from India from the operation of provisions of clause F of subsection 2 of section 6 of the Act, subject to the following terms and conditions. Number 2 is the one is the passport to be issued on every citizen shall be issued for a period specified in the order of the court referred to above, if the court specified a period for which the passport has to be issued. If no period either for issue of passport or for travel abroad is specified in the order, the passport shall be issued for a period of 1 year. Now, next, if such order gives the permissions to travel abroad for a period less than 1 year, but it does not specify the period validity of the passport shall be issued for 1 year. And next 4, if such order gives the permissions to travel abroad for a period exceeding 1 year, but does not specify the validity of the passport, then the passport shall be issued for the period of travel abroad specified in the order. So, my lord, everything has been specified. Now, my lord, today, my lord, your lordship, my lord, can you see? So far as the Delhi High Court judgment is concerned, I just point out one thing. Delhi High Court.
Whether this was appealed against this order?
No, the appeal is pending. Nothing has been decided till now. Now, appeal
is pending.
Appeal is pending. Now, so far as this until unless time is specified. Kindly have a look. Once again, the order passed by the criminal court. If you last have seen it, your criminal court passed an order for given direction for renewal and deposit the passport before the criminal court. Now, there is no time specified. If it is not specified, it cannot be equated with Rule 12. Rule 12 is applicable so far as not in normal ordinary citizens are concerned, not against whom the criminal cases are pending. So, Rule 12 cannot be placed into service for the purpose of seeking passport for a duration of 10 years. Now, my lord, again, my lord, so far as Delhi High Court division bench judgment is concerned, my lord, with deepest of respect to the my lord, division bench, my lord, I say the division bench and proceeded on the basis there is no delegated legislation. My lord, just point out my lord, one paragraph of Delhi High Court judgment. Can you have a look? So this is my lord, paragraph 30. The Kaushala was quoted. Paragraph 30. Can you take my lord, Delhi High Court judgment? That is, my lord, Vinda versus Rajagopal Chakraborty.
Yes, yes.
Now, my lord, can you transfer paragraph 30?
Yes.
Paragraph 30, my lord, the Kaushala Devi was quoted. Now, in Kaushala Devi, my lord, can you see, my lord, the Kaushala Devi is paragraph 13. Now, my lord, can you see Kaushala Devi is paragraph 13. That is also quoted. Just, my lord, it starts, it is established. It is well established. I will also got it. It is well established that the delegated legislations cannot be transgressed the limit of the enabling statute. The Supreme Court, in the case of such, must confirm the delegated legislations or the subordinate legislations must confirm exactly the power granted. In Naresh Chandra Agarwal versus such, the Supreme Court reiterated the hell.
Where from you reading?
But Kaushala Devi, my lord, paragraph 30. Then, my lord, paragraph
9 quoted.
Paragraph 30, thereafter, my lord, you will also find 9 quoted, paragraph 9 quoted.
Yes.
Now, my lord, then, my lord, can you turn paragraph 9, thereafter, paragraph 10, 11, 12, 13. Next to next page.
Okay, it is well said.
Yes. Now, can you see, my lord, it is said, it is well settled that the delegated legislations cannot transgress the limit of the enabling statute. The Supreme Court, in the case of such, a delegated legislation or a subordinate legislation must conform exactly to the power granted. In Naresh Chandra Agarwal versus such, the Supreme Court also reiterated, held that while the rules and notifications issued under the delegated authority may be presumed valid, they must not override or supplement the parent act. A notification cannot be treated as a source of substantive obligation unless the statute itself clearly permits such delegation. Well, here the statute permits me to, section 21 permits the issuance of such notification. And section 22 also permits for issuance of notification giving exemption under section 6(2)(f). So, these things, section 21 and section 22, has not been considered by the Delhi High Court, with deepest of respect, in two perspectives. Section 6(2)(f) is normally applicable, normal case, if against me the criminal case is pending, I cannot apply for passport. Section 22 exemption. So we are applying the exemption. If the criminal court gives me passport for 10 years, we will issue that.
Okay.
But these are my submissions, Lord.
Thank you. Yes.
You kindly take the rules. Lordship, kindly take the act first. Act. Lordship has the act with you.
Yes.
Lordship kindly comes to section 24 of the act.
Section 24.
24.
Yes.
Power.
Correct.
I am on 24(2). In particular, and without prejudice to the generality of the foregoing provision, such rules may provide for all or any of the following, namely, I am on B. The period for which passport and travel documents shall continue in force. That is a rule that can be made under the rules. And the rules which are there, Lordship kindly takes a look at the rules.
No, Rule 24, the section 24, the central government by notification in the officer make rule the carrying of the purposes, in particular without prejudice to the general program, appoint the jurisdiction, classes of the person from the particular applications, period for which the passport travel document shall continue in force. Yes.
The rules may provide for duration of the passport travel document. Rules here, under rule made under Rule 24, prescribes 10 years. If they wanted to curtail this period, a rule was required. Lordship kindly takes a look at the passport rules. This is made under section 24. Made under section 24 of the Act.
Yes.
Rule 12. An ordinary, this is an ordinary passport, nothing special diplomatic. An ordinary passport for persons other than children below 15 years, containing 36 or 60 pages, shall be in force for a period of 10 years from the date of its issue. If the, and now logically takes section 22 of the Act. In contrast, distinction with Rule 24 2D, read with Rule 12, can it take section 22? What is the power under section 22? Where the central government opinion that is necessary, expedient in public interest to do so, it may specify exempt any person or class of persons from operation of any or all of the provisions of the Act. So what they can exempt? They can exempt a class of persons from 6(2)(f).
Where the central government is of opinion, if it necessary, expedient in public interest to do so, it may by notification of official such condition, if exempt any person or class of persons from operation of all or any of the provisions of this Act or the years, as often may be cancelled or such notification. Yes.
Now, Lord, you kindly takes a look at section 6. Section 6, subsection 2, if it's applied, a certain class of persons are not entitled to a passport or renewal of a passport. Section 6(2).
6(2)(f), yes.
First one, applicant not a citizen of India.
Correct.
By notification under 22, this could have been exempted for all Bangladeshis. They can get an Indian passport, or for all Nepalese. But that notification couldn't have said for Nepalese it will be 5 years. So that is a rule-making power.
No, refusal of passport of travel document of the other provisions, the applicant may like. So subject to the other provisions, authorities shall refuse to issue passport of the travel document for visiting a foreign country under the clause C and of section 2 of section 5 or any one more of the following. So these are the ground I, A to I.
Yes.
Correct.
Now we are concerned with F. E has not been exempted. E still remains the other persons who cannot have a travel license. They don't have a travel license, say for somebody who's been convicted. 22A can exempt a class of persons from some of the provisions of the Act. This exemption is from 6(2)(f). Section 6, subsection 2 excludes certain classes of people from getting a passport.
Correct.
Now, by 22 notification, certain provisions of the Act can be made not applicable. Exempt any person, I'm reading it to 22, exempt any person or class of persons from the operation of any of the provisions of the Act.
Correct.
So, say for example, let's take 6(2). Let's come to now 6(2). Let's take for example 6(2)(a). 6(2)(a). Section 6(2)(a) excludes all people other than citizens of India from getting a passport. Let's take, and on no other ground, namely that the applicant is not a citizen of India. So not a citizen of India, nobody can get a passport. There may be by section 22 or notification under 22, this operation of 6(2)(a) may be exempted in case of, say, just example, Brahmins from Nepal, or the Hindus of, I'm sounding maybe.
That's what 6(2)(a). 6(2)(a) categorize the person. 6(2) categorize the persons who will not get the passport.
Now 22 can exempt certain classes from 6(2).
Correct.
So it may exempt, say I'm saying all the Indians living, having
22
citizen.
powers of notification of a function exercised by the period of census. D of section 2 of section 2 of the section. Yes, exempt that.
See, all Indians born in, born Indians who are citizens of America, they will be exempted from the operation of 6(2)(a). So they can be getting passports. So Indian born American citizens can get a passport by notification under 22. 22 can make a notification. 22 can make a notification exempting all born Indians who are American citizens from the operation of 6(2)(a). Could be done. What has happened here is by a notification under 22. 22 exempts persons who are from the operation of 6(2)(f).
Again, that's why now we have to take the serially. Correct.
Yes.
6(2)(6) section 6 provides for refusal of passport. Correct. And 6(2)(a) or 6(2) provides with regard to the what are the grounds.
The persons who
will not be entitled to get the passport. In that clause F with regard to this petitioner. Correct. Now come to the 22.
22 has the only exemption
for the exemption clause.
Only exemption.
Exemption where the central government is of the opinion that it is necessary or expedient in the public interest to do so by notification. Correct. Okay. So by notification, now come to the notification. Now come to the notification in the act itself or your petition. 218. 218, they have exempted, they have passed an order. The passport to be issued to every such citizen shall be issued for a period specified, referred above in the code specified for which the passport is to be issued. That if no, first is for the period specified in the order of the court referred to above. Let it be read together. 1470-76, central government opinion is necessary in public interest to do so hereby exempt the citizen of India against whom the proceedings in respect of the offences alleged to have been committed by them are pending before the criminal court in India and who produce orders from the court concerned permitting them to depart from India from the operation of the provisions of section clause F up to of section 6. Then these are the criteria. Now, first criteria is for the period specified in the order of the court referred to above. If the court specified a period for which the passport has to be issued, then they will give the. So they will give the if the court grants 2 years, 5 years.
Persons are exempt. That class of persons are exempt.
Correct.
From 6(2).
If no period either for the issue of the passport or for travel abroad is specified, then it is restricted for 1 year. It is restricted for 1 year. So what is the submission on your submission?
My submission is 1 year period fixing can be only under section 24.
Because
only
so they can only exempt, they cannot put the condition. As per your
24 specifically, yes, but that is it. My long and short is that 24(b) says that the rules have to be amended. That's for this kind of people.
That's why
after notification the rules.
So the government can exempt whatever it is, but they cannot impose. They wanted to impose, they go for the
and especially when subsection 3 provides rules are of a higher category because this is placed in the parliament. Section 24(3). So for limiting a period, it has to be section 24(3). Every rule that shall be laid before the house. So rules have a different procedure. So the period is to be fixed.
But what about the coordinate bench judgment?
But has not considered this rule 24. So that's why rule 24 has not been considered. Section 24. I mean 24 not considered. This is pending on appeal, so it's lost its finality. And then, my Lordship, can you take a look at Bhai Agarwal's case, Supreme Court, when Lordship there were 2 criminal cases pending. One in Delhi, that is One in Delhi was a
One of
case,
the Supreme Court.
and one before the Ranchi.
Ranchi, NIA court.
NIA Act Ranchi, and there's one coal scam in Delhi. Delhi firstly gives them permission to have a passport for 10 years, Delhi High Court. I mean, that in that criminal case. In that criminal case. But then, NIA Act, when they came to Ranchi, Lordship takes a look at the Delhi, at the judgment of the Supreme Court. NIA Act Ranchi passed an order exactly identical words as our case. Leave passport given back for renewal, but travel by permission. Supreme Court says notices section so then Supreme Court in the NIA Act case, since there was no such time period fixed, the question came up whether it be 1 year or more. Supreme Court said 10 years.
Yeah.
Which 10 years? In Mahesh Agarwal. This comes after Mahesh Agarwal's case. This is after the Calcutta High Court judgment. Lordship kindly takes a look at this judgment. Paragraph 4.2. Page 2. There are two cases. The appellant is an accused in a case investigated by the NIA arising out of Tandwa. The NIA re-registered the case as a RC so-and-so, alleging extortion so-and-so, under the Unlawful Activities Act. Now, kindly come to then paragraph 4.5. The CBI case for coal scam, in the coal block scam, 4.5. So there are two cases pending.
Yes.
Now kindly come to paragraph 4.7. 4.7 and 4.8. Yes. As the date of expiry of his passport approached, the appellant filed an application before the NIA Court Ranchi seeking no objection for renewal of his passport for a further period of 10 years and for release of the passport for that limited purpose by order dated so and so. NIA Court noted that the passport bearing number so and so had been issued on 29th August 2013 and was valid till 28th of August 2013, and that the appellant had applied for no objection for renewal passport for 10 years. By the order dated 10th July 23, Ranchi, NIA Court Ranchi directed that the passport of the appellant be handed over to him for a limited purpose of renewal. Upon his furnishing an indemnity bond of so and so with two sureties. The appellant was directed to remain physically present for framing of charge 31st July and to receive the passport himself. The appellant was also required to file an undertaking that he would not obtain any visa to travel outside India after renewal of the passport without permission of the NIA Court, Ranchi, and that he would deposit the renewed passport immediately after court. So that was no time period was fixed by the Ranchi Court. Now, in the meantime, the Delhi High Court in the CBI case, kindly come to paragraph 4.0. By order dated 4th September 23, the Delhi High Court, after noticing its earlier condition imposed in the order of 23rd May that the appellant shall not leave the country without permission of the court, held that there was no basis to deny or renewal passport for a regular period of 10 years. The Delhi High Court gave no objection. Now, but the Ranchi Court remains as it is. Now, Lordship, kindly come to 4.13. 1.2 and 1.3. On 17th October 23, the appellant appeared before the RPO Kolkata and produced certified copies of the order dated 4th September passed by Delhi High Court and order dated 10th July passed by the NIA Court. He requested for renewal of passport for 10 years. The respondents examined the application in the light of 6.2f. and this 93 notification issued under section 22. According to the respondents, the appellant could be exempted from the bar under 62F only if the competent criminal court expressly permitted his departure and specified or at least enabled the period of travel in terms of so and so. Since the NIA court Ranchi had granted no objection only for the limited purpose of renewal of passport, had directed deposit of the passport and had not granted permission, the respondents took the position that the statutory bar under 62F continued to apply. The regular 10-year passport could not be issued.
Yes.
Now, writ petition is filed, paragraph 4.14, for renewal of 10 years. Before the final decision was communicated, the appellant approached the Calcutta High Court for a 10-year passport. Then kindly come to writ dismissed. A 10-year passport can't be given. 4.16 appeal division bench dismissed. Now kindly come to 4.17. What did the division bench say? By the impugned judgment and order of 4th April 25, the division bench dismissed the appeal and affirmed the reasoning of the learned single judge. It held that there existed...
It is our court.
Our court. It held that there existed a statutory embargo under 62F of the Passport Act in view of the pending proceeding before NIA court Ranchi and that the subsisting conviction in the Delhi case, and that in the absence of an order from the competent criminal courts permitting the appellant to depart from India in terms of GSR, that is the 93 notification, the passport authority could not be directed to reissue a passport for a regular period of 10 years. At the same time, the division bench clarified that it did not wish to foreclose the appellant's right and left it open to him to approach the Delhi High Court and the NIA court Ranchi for appropriate directions in accordance with law. Now, it goes to Supreme Court from that. Now, kindly come to paragraph 11 of this judgment.
Yes.
The office memorandum of 10th October 2019 does not create a new regime. The 2019, where is the 2019? You kindly give me 1 minute.
What is the OM 1010?
I'm just checking that. I am just checking that, mother. 2019.
Paragraph 4.13 refers to OM dated 10.
Paragraph 4.13 refers to the 2019 circular. Seems to be on the same lines as 93.
And OM, yes, might be. Must be strictly applied to explain the procedure of criminal cases. Yes.
7.9. 7.9.
Is there.
7.9.
Referred the provision that referred that. 7.9.
Yeah. Yes.
Yes.
External Affairs, OM of 2019, by page 23.
Oh, apply this GSR.
Yes, same.
GSR 570.
Same.
Nothing. Yes.
No, nothing more. Now kindly come to paragraph 12 of this judgment. Paragraph 12. Proceeding on the same assumption as the Calcutta High Court, we are prepared to treat reissue of an expired ordinary passport as referable to Section 5 and subject to 62F. Even on that footing, the question is whether the embargo under 62F remained absolute in the appellant's case or should relax by virtue of the orders of the Delhi High Court and NIA, Ranchi, which brought him within the purview of the 93 notification. In our view, once criminal courts with full knowledge of the pending proceedings. Consciously allowed renewal subject to the condition that the appellant shall not travel abroad without their permission, and in the case of the NIA Act, required redeposit. The underlying concern under 6.2f adequately addressed under judicial supervision. So then I come to Rule 12 straight away. I come straight to, so 6.2f is taken care of, read with the Section 22 notification, I mean exemption of 1993 under Section 22. Paragraph 13 goes on with the same line. Paragraph 14, very important. We are also unable to agree with the view that the appellant could not fall within 6, because the NIA code did not itself mention 10 years. The appellant's application before the court so ordered for a regular period of 10 years. Now, Lordship kindly comes to paragraph 18. Paragraph 18 is general principles, but one of the basic pillars of our judicial system. The fourth line, however, this court in Bangala Kasturi Rangachayu case has already drawn a clear distinction between an accused facing criminal trial and the person who has been convicted, and is pursuing an appeal and how the same can impact the issue of passport. The refusal of a passport can be only in case when applicant is convicted during the period of 5 years immediately preceding the date. 6.2 have laid to a situation where applicant facing criminal trial. Admittedly, at present, the conviction of the appellant stands still the disposal of the criminal's appeal. The sentence which he has to undergo is 1 year. The passport holder cannot refuse renewal period of deficiency of passport to renew. Now, paragraph 20. Paragraph 20. It must also be noted that denial of renewal of passport doesn't operate in vacuum. This court has repeatedly held in a catena of judgments that the right to travel abroad and the right to hold a passport are facets of the right personal liberty under Article 21 of any restriction on that right must be fair, just, reasonable, and must bear a rational nexus for a legitimate purpose. The legitimate purpose behind 6.2f and section 10.3 is to ensure that a person facing criminal proceedings remain amenable to jurisdiction of criminal court. That purpose is fully served in the present case by the conditions imposed by NIA. And Delhi High Court, which required a person to seek permission before for any foreign travel. Para 25 is the reasoning given. In the light of the above discussion, we are unable to sustain the approach adopted by the...
Can you read the 24?
25.
24.
24. Finally, even in the own reading of GSR 570, the consequence of an order which does not specify a longer period of validity is that the passport should be issued for a shorter period, usually 1 year, and not that the renewal will be refused.
1 year and not
Usually. That is the other side's contention.
Yes.
The learned single judge and the division bench did not examine this aspect because they proceeded on the premise that the appellant should outside the exemption altogether. Once it is recognized the appellant is within the exempted class, the correct question for the passport authority is the appropriate period of validity in the facts of the case, not whether any renewal is permissible at all. In the present matter, given that the Delhi High Court has expressly authorized renewal for 10 years and the NIA Court has imposed stringent restrictions, conditions including redeposit and prior permission, we see no justification to curtail the normal period of validity.
You left that paragraph.
I missed it, but I'm sorry. Actually, I am grateful to my Lord. I am very grateful to my Lord. Part 25, in the light of the above discussion, we are unable to sustain the approach of the learned single judge under the division bench. Both have referred to 6.2f as an absolute bar. so long as any criminal proceeding is pending, without giving full effect to the statutory exemption under 22 GSR, and without adequately appreciating that the criminal courts actually dealing with the appellant's case have consciously permitted renewal while retaining stringent control over any foreign travel, like in our case. They have in effect converted a qualified restriction designed to secure the presence of an accused into a near permanent disability to hold a valid passport, even where the criminal courts themselves do not consider such a disability necessary. All the sections have been considered. 6, 7, 9, 10, 22 of the Passports Act and the OM on the present fact. We express no opinion. And paragraph 30, 10, respondents are to issue and Lordship's ordinary passport for 10 years. Now, Lordship sees this has been considered by the Delhi High Court in paragraph 33. Paragraph 33. Delhi High Court, page 14 of the Delhi High Court judgment, page 15.
Yes.
After quoting Mahesh Agarwal, therefore the reliance placed by the learned counsel for the appellants to argue that the Honorable Supreme Court has directed that where the court has not specified any period, the renewal can be only for a period of 10 years. 1 year is also misconceived, as the Supreme Court has only recorded the provision of it by stating that the appropriate cases, Passport Authority has power to issue passport for a shorter duration as well. And that's why they have to give reasons. In view of the above, the decision of the Mahesh Kumar Agarwal does not lay down that in the absence of a court-specified period, the Passport Authority is denuded of the power to renew for a period exceeding 1 year. The legal position, as enunciated in Kaushalya Devi, is unequivocal that where the court has not specified any duration, the renewal of the passport must be considered strictly in the appropriate acts and the rules.
Yes.
So, I am distinguishing the judgment of our High Court on two grounds. Section 24 was not considered. Section 24, 2G was not considered. Only the rules placed in the Parliament can limit the period, it can prescribe the period of travel, period of renewal, which is there under Rule 12. A notification which is even subordinate to the rules cannot override section. This notification exemption is fine, but period overrides section 24 2D, but because that encroaches upon the rule-making powers of the government.
Yes.
So 24 not considered. Mahesh Agarwal has enunciated the law subsequently, so in my humble submission, and also when appeal is pending, not their judgments not carrying them, that when appeal is pending, then in that case, the judgment loses its finality, even for outsiders.
Yes. Thank you.
Well, only two things will I say. So far as Mahesh Agarwal is concerned, Lord, NIA Court, Delhi High Court. Delhi High Court will not directed the passport to be renewed for 10 years. NIA Court will not did not say anything. No, the Delhi High Court says it passports to be renewed for 10 years.
Prayer was 10 years.
10 years. Then Delhi High Court directed for 10 years. So, can you have a look?
Considering the condition imposed that he has to surrender.
Yes. Delhi High Court said, Milord, kindly just one page, Milord. I'm just referring one. Kindly see, Milord, paragraph 10. No, kindly see paragraph 14, Milord.
Yes.
Paragraph 14 says, we are unable to agree with the view that the
paragraph 14 of?
Paragraph 14 of Milord Mahesh Agarwal.
Mahesh Agarwal.
Yes. Yes. Now, prior to that, Milord, you lost, Milord, can you take paragraph 4.10? Paragraph 4.10. 4.10 says, Milord, Mahesh Agarwal.
Yes.
By order dated 4th of September 2023, the Delhi High Court, after noticing the earlier condition imposed in the order dated 23rd of May 2022, that the applicant shall not leave the country without permission of the court, held there is no basis to deny the renewal or issuance of passport to the applicant for a regular period of 10 years. The Delhi High Court accordingly granted no objection and permission for renewal of the petitioner's passport for a period of 10 years. So, Delhi.
That's why
Yes.
taking into consideration
Yes.
the condition imposed.
Yes, yes. The Delhi High Court, my lord, has granted.
Because he has to surrender the passport. He has to
And
surrender.
the logic is, the court is in control of the accused.
Correct.
Whether the court is in control of the accused or whether my lord, he is another subject, his roommate is subject to court control or not. This is the logic. Now, my lord, in this case, my lord, you will also find there are two criminal cases pending against him. In none of the cases, my lord, there is no such duration has been prescribed. No such duration.
Not such.
No such duration.
Okay, that is admitted.
That is admitted. Now, my lord, if the no such duration, now, my lord, your lordship will not kindly also consider, my lord, so far as Mahesh Agarwal case and other case and all these things, my lord, my notification was subjected by the Supreme Court and High Court and all these things. There is a clear-cut judgment given by the single judge of the Supreme Court. It is intravirus. The Supreme Court did not say anything whether it is intravirus or ultravirus. Supreme Court did not touch.
Relied upon.
Yes. Now it is relied upon.
The High Court and the Supreme Court have relied upon. It is not decided. It is
nothing has been decided regarding this notification is concerned.
If they will take both the judgment of Supreme Court and Delhi High Court, they are of the view. So your notification says if it is not period, it is 1 year. But the Delhi High Court and Supreme Court says if the criminal court is session of the matter and you have applied for that, there is a condition, so authority has to act. Renew in terms of your rules and
regulations. So, if the criminal court will not direct us to renew the passport for a period of 10 years, 5 years, whatever it may be, then we will go by the order of the criminal court. But if there is no such period is prescribed, then my notification stands. These are my arguments.
Notification, okay. That they have neither Mr. Mitra has challenged, not the.
So Mr. Mitra is saying
Mr. Mitra is challenging with regard to the notification of 93 is exemption if and not for imposing condition. If it is imposing condition, then you go to the section 24.
Duration, if you are going into
duration is exemption, okay, passport can be renewed, that is exemption. If you are giving some condition, imposing condition, duration, that's why the imposing condition of the duration, then it is not coming under the purview of 22, then it will come to the 24, you have to go by the relaxation.
Kindly consider one aspect. Exemption means exemption to some extent.
I am telling what the submission. If I correctly understand the submission of the submitter.
That's why I am saying exemption means the exemption.
Not pronouncing
That's
what the interpretation of Mr. Mitra, so that
no, it has to be interpreted whether the exemption means full exemption or whether it means exemption subject to the discretion to be exercised by the central government.
Correct.
That is.
Thank you. Hearing concluded, CAV. I am keeping this.
Yes.
Yes, next.
My lord, I appear for the petitioner. I am led by Mr. Vikas Ranjan Bhattacharya. He is online.
But the issue before your lordship is well settled by your lordships following the Supreme Court judgment that when my lord question of donation of kidney comes, the basic consideration should be whether there is any commercial transaction or not.
Correct.
If there is no commercial transaction, my lord, the authority cannot withhold the permission.
Correct.
Here I find, my lord, the report filed by them, the annexure E, they clearly say there is no commercial transaction. The other issues, my lord, were really incidental to the main issue relating to commercial transaction. The other issues would not have, my lord, the preference over the basic issue. Where there is any commercial transaction, no. There, as my lord got it with page 11 of the report.
Yes.
First point, whether there is any commercial transaction, no, there are no unofficial financial dealings in cash or kind between the donor and the recipient as per the affidavit from first class magistrate and declaration of the donor and the legal guardian.
Yes.
Therefore, if there is no commercial transaction, and which is also the finding upon the inspection, the subsequent issues, whether he could properly show the address or not, this becomes absolutely unnecessary redundant.
Yes.
And just on the other day, my lord was pleased to pass an order, though I was supposed to appear, I could not appear, on the same point. That order of my lord, I asked my junior to hand over to your lordship. Really, I'll be governed by that.
No, whether that yesterday's judgment.
Yes, my lord, my junior authority was there, and he had argued. He informed me that your lordship was pleased to, my lord, grant permission on the bail consideration that there is no commercial transactions. Other issues are not very relevant.
No, other than the within the transaction and with regard to the relative, it is unrelated. Then
Unrelated means
is unrelated. Then you from
yes,
the
commercial transaction arises when there is, my lord, not the next to kin donor. If there is a next to kin donor, that is not an issue. But if the donor is, my lord, not related closely, then question comes of commercial transaction.
Now, what is in the CD? Have you gone through? Right?
That I have already submitted.
You have submitted. Have you gone through? Because on the last occasion, you submitted, you're not there. And your report is something. When this court has examined the CD, what is your report and what is in the statement in the CD is totally different. I thought your officer should have been given something, but I left that.
These are all basic human consideration. Whether the physical inspection would have done it, I don't know. Anyway, lordship, kindly pass the order.
So,
I have not gone through the CD. And
why? You are appearing with the court. You could have been test
my
the
lord,
CD
on last
and the
occasion-
report.
Yes, my lord. On last occasion when I am appearing, that time I got the CD, my lord. So
Correct. So you
submitted
could have
before
been
your
checked.
lordship,
You
my
could have been checked, taken the next access CD. Then the court has to examine all these things sitting here. Okay, I will pass out. I will see the
My
CD.
Deeply obliged.
Much.
CAB. Because CD has to be seen because they are not able to produce the where. Henceforth,
Yes,
you
my lord.
come with the what has been stated. Come with the statement.
Yes.
That is the main thing. What is the purpose of examining the witness
Yes, ma'am.
donor by the verification committee? Only not to see the face. Verification, you are examining the donor and the recipient. What the statement? So that because see unrelated person, there might not be a linkage. There might be a document, but from the statement and all the things is to be collectively ascertained. Yes, it can be presumed that there is a unrelated relationship with them.
Yes, ma'am.
Yes, next.
I have given you notice the book of Proceedings here at 1994.
It is given.
Last submission it was.
और कल लाके दिया वाला वही वाला होगा.
Yes, my lord, your lordship can.
ठीक है, I will see. देख लेना फाइल में होगा. Yes, next.
I am for the petitioner, my lord.
In the state, my lord.
My lord, the matter relates to my lord.
Yes.
My lord, the matter relates to my lord transplantation of my lord kidney, my lord, of the petitioner. My lord, petitioner suffering from my lord renal disease stage 5, my lord. Thereafter the petitioner was certified that he needs transplantation, which is at page number 27. Thereafter, after
What is the report? Verification report?
my lord, we have not.
Lordship, kindly see clause 5. I got the report, my lord.
Huh? Clause
I got
5,
the
reason of the
clause
donor.
5, my lord.
Donor wants to give the kidney to the recipient of humanitarian ground as per the affidavit and hearing. Yes.
Lordship, the sole rejection, my lord. The ground of rejection is at page 11 of my report, my lord. Page 11 of my report.
Page?
11, my lord.
11.
Lordship.
Yes. And NOC of donor case is not recommended at this end. Why?
Lordship, the finding, my lord, it is the report of the AA, my lord, in review, my lord.
Huh?
The in report, my lord, in review report.
Which report?
Interview report, my lord.
Interview report. Where is
Report,
the
my lord.
interview report?
Which is the same page at clause 9, my lord.
9.
Clause
Interview.
9, my lord.
Hearing is video recording may compare this and other.
Let us say,
As per the statement of the donor, husband was staying at the Sonari at Jamshedpur for the last 10 to 12 years and did painting works of the recipient house. As per the statement of the legal guardian, the recipient donor husband did not work at their house and they were staying at the Sanchi. And the statement of relationship between the donor and recipient is not beyond the reasonable doubt. Yes.
My lord, may I come back with the instruction regarding this? my lord?
Absolute
My lord,
contradiction.
If you have
I have
contradiction, you
though my lord, in my
if you're
petition,
trying to linkage relationship between the donor and those, you're telling that you are the painter working here.
Lordship.
my lord, in my petition, though it is written, they have made through the family, if friends, take instruction regarding this, my lord. Definitely.
Learned Counsel appearing for the estate has filed the report after serving the copy to the Learned Counsel for the petitioner. Learned Counsel for the petitioner has drawn the attention of this court for reason of not recommending the case for transplantation of the organ for transplantation of kidney.
Yes, your lordship.
Kidney. Learned Counsel for the respondent has submitted that in the interview before the verification committee. As per the statement of the donor, her husband was staying at Sonari of Jamshedpur for the last 10 to 12 years and did painting works at the recipient house. But as per the statement of the legal guardian of the recipient donor, guardian of the recipient donors. But as per the statement of the legal guardian of the recipient donors, husband did not work at their house and they were staying at Sanchi. Learned Counsel for the petitioner prays for time to take instruction. According to cases adjourned, let the matter appear on how much? 1 week?
Yes, your lordship. 1 week.
Let the matter appear on 11th August under the same heading within 10 minutes. Next.
Grateful, your lordship.
My application. Very short matter, my lord. My client in lord was a director of company Concast Limited. My client.
Wait, please, your lordship, Millard. I am appearing on behalf of the respondent bank, Millard. Millard, I have sought for instruction, Millard. I just require 3 days time to get some documents relating to this, Millard. Millard, the writ petitioner has relied upon few documents by the bank, Millard, but has not been annexed. I have sought for direction, Millard. 2-3 days will suffice.
Direction of seeking law to supply certain documents. I prayed for some documents. They have given some documents, but not has left the other documents. Without it, I am unable to give the reply to so-called notice. And as to why.
Let them come. Learned Counsel for the respondent bank prays for time to take instruction. According cases adjourned, let the matter appear on 12th August.
Much obliged, please.
Under the same heading within 12th August.
12th August. My lord.
Next. Within 10 matters.
Within 10 minutes. I would like to.
Item number?
10.
Yes.
The petitioner here have availed a financial assistance from the respondent bank in the year 2025. And thereafter on 14th of November 2024, the bank has issued no use certificate. But thereafter, they have not updated the civil score of my client. So, Your Lordship, thereafter,
civil score is automatic.
Your Lordship, since 2024, I have tried to get another loan from another bank that is annexed at P5 at page 42 of my writ petition.
45.
42, Your Lordship. Annexed at P5.
Initially,
here I have initially it was granted by the ICICI Bank at page 41. If Your Lordship comes, that is the no dues letter issued by the ICICI Bank. Thereafter, at page number 42, Your Lordship, the SBI has informed that we would like to inform you that a days past due DPD entry of 465 is reflecting in one of your loan accounts in the credit report. This indicates that a past credit obligation has remained overdue for a significant period of time, which had affected your credit score and impacted your eligibility for new credit. That is on 26th of May 2025. So I have repaid the entire loan amount on 24th of November 2024. That has been 14th of November 2024.
That is with regard to the ICICI Bank.
Yes, Your Lordship.
And this is
And
of the
only
State
that
Bank.
loan I have availed. And thereafter, if the loan is
You have only one loan.
yes, Your Lordship, from the
ICICI Bank.
the ICICI
And that you
and no dues letter has been
that you have paid and you received the no dues.
thereafter, Your Lordship, I am relying.
No, so why the State Bank of India issued this letter?
Because I have later approached the SBI for a fresh loan. And at that point of time, SBI has checked my CIBIL score and informed me that DPD entry is showing there. Thereafter, I have informed the civil authority accordingly. They have not taken any steps, Your Lordship. Now, my Lord, I am relying upon an RBI circular that has been annexed at page 56, annexed at P7.
56.
56.
Hmm.
This is a framework for compensation to the customer for delayed updatation or rectification of credit information. Now, may I read it, Your Lordship? From the explanation part. A CI shall pay compensation to the complainant if the CI has failed, that is explanation 1 to 3 and thereafter B. Has failed to send updated credit information to the CICs by making an appropriate correction or addition or otherwise within 21 calendar days of being informed by the complainant or a CIC. So CIC here is the ICICI Bank. Whether they have sent the information to the civil authority or not, we do not know. Later on, Your Lordship.
What is the meaning of CI?
Credit Information Company.
CI shall forward the corrected particulars of the credit information to the CIC or the complainant within a period of 21 days from the date when the CI has informed of the inaccuracy of the credit information. Yes.
So they have not informed you.
Hmm.
It is clear because the SBI has stated that my CIBIL score is not updated. Thereafter, I made another representation that is at page 57.
90? 57.
57, Your Lordship, annexed P8.
So you made a representation. Nothing
Made a
has been done.
representation to either give
So
me some
there's
compensation.
there's no report. There's any reply.
No reply has been given by. And Your Lordship, I am relying upon.
What about the 63? What about the 63? Page 63 is the civil report. What says?
Your Lordship, that report they have just,
What the civil says? Appearing CSR delivered basis so. Further,
at page number 64, Your Lordship, Roman 4. In case of any grievances, credit information, the credit information company like TU Civil can only take up a grievance of a person regarding the credit information with the credit institution that has submitted the concerned information as per CISR
Yes.
Act.
Yes. So, now what is the
So
what is the prayer?
My prayer is that my information has not been supplied by the ICICI Bank to the civil authority. For such reason, I am entitled to some compensation and also my civil score should be updated, Your Lordship. Your Lordship, I am relying upon two judgments, Your Lordship. The citation is 2021 SCC Online, Kerala 221, Your Lordship. I am relying upon para 12 onwards, Your Lordship. Okay. Para 12 onwards. I am reading it out, Your Lordship. Section 21(3) of the Act, that is Credit Information Companies Regulation Act. This is the
Act, your lordship.
Yes. Yes, what is the stand of the authority? Bank? You are
Yes, my
applicant
lord.
for?
ICICI Bank 234. My lord, respond number 2, 3, and 4. If your lordship kindly comes, paragraph 5 of his application.
Of the?
Application, my lord.
Yes.
Your petitioner states that thereafter time to time your petitioner was paying its EMI. However, due to blockage of payments by various concerned authorities, the payment of salaries of staffs and other expenses, the generation of working capital got stopped and repayment of EMI became irregular. It is further stated that in this context, that your petitioner had duly informed the same to the officials of restaurant number 2, that is the ICICI Bank. They have assured your petitioners that nothing will happen to the loan facility availed by your petitioner. It is relevant to be mentioned in this context that almost rupees 2 lakhs has been repaid by the petitioners to the bank from 16/12/2022, 24th of February 2023. So thereafter, payment was not made.
No, no, that's correct. Then what? Why you issued the certificate? Kindly come to the page.
Yes, yes, madam. I'm coming. I'm coming. Kindly allow me. Then, my lord, kindly comes to paragraph 7, my lord.
Yes.
A petitioner states that thereafter, on and from 21st October 2024, my lord, there was a due from February to 23rd October 24, almost 40 lakhs were repaid by your petitioners as full and final settlement of the loan account. However, even after receiving the same, the bank authority remained reluctant in issuing no due certificate. Thereafter, my lord, no due certificate was issued. Now, my lord, so far civil is concerned, if your lordship kindly comes. My lord, kindly comes to page 43.
Yes.
It is bit illegible.
Yes.
My lord, kindly sees the report dated 7th of August 2025.
Yes.
Left hand side at top.
Yes.
I am so sorry, right hand side, my lord. Then, my lord, kindly comes in the middle page. It is written as এটা কি লেখা আছে পড়তে পারছো?
Reported
মানে it is
description reported discrepancies reported.
Discrepancy reported in perhaps on the borrower, my lord.
Yes. Discrepancy reported on the borrower.
Yes.
Your institution current no. Last
Current?
20 months no. Outside current yes. Last 24 yes.
24 months there was due.
Yes.
So it was reported.
No, that is on August 2025.
Yes.
That is
last
August
24 months, my lord.
Last 24.
October 24 he has paid.
Hmm.
Default was there earlier to that. Before October 24. So it is this 24 months covers that defaulted period.
Oh.
But because there was a due.
Sir, there was a due.
Yes.
August 25, it's okay, no problem at all. Okay, there was a due.
I'm coming to
but
that.
on October, the due has been paid and you have issued the certificate. So
Yes.
how you can treat further 12 months?
No, I have not. I have raised not any information after payment of his dues.
That's
yes,
only the question here. Only the question before
kindly comes to page 47.
In the present date application, after you receive the totally loan amount, including the interest, whatever it may be, you have issued the certificate, not due certificate. So why you have not informed to the civil?
My lord, kindly comes.
Page?
Page 47.
Yes.
এখান থেকে বোঝা যাচ্ছে কি?
That is also 7th August.
My lord, it is also 7th August.
Correct.
Now, my lord, dues are shown as September.
Correct.
Thereafter, no dues were shown. So thereafter, my lord, loan got closed. That was informed to the civil. Now, kindly see, default was mentioned till September.
Where is that?
At the top, my lord, top row, page 47.
47.
Kindly see, dues were shown till September.
Sir, till September 41 lakh 42,730.
That was shown.
Yes.
After he made payment in October.
Yes.
Now, kindly see, it is blank.
Correct.
So whatever will be default for each month, that will be reported to civil. That was reported till
No,
September.
Till September.
Till September.
Correct.
So
who is appearing for this SBI?
No, not SBI has not been made a party.
You,
The civil authority.
This SBI, you are directing that the civil report is there. Your contention
That is why I have made a party to as a civil authority, Your Lordship.
Who has issued the notice?
The SBI has informed.
SBI has to say we don't know whether the SBI, which document the SBI got it.
That
Yes,
I don't know.
what is the instruction?
We have updated the offline maintenance form as per the current data available to the committee.
What is the data?
Well, this report was provided by SBI only.
Data as
Ah.
30th September 2024.
2024.
We have given a mail to.
This is 2022. What about the 25 after the payment? Kindly come to the page 47.
Thereafter, no. Data has been submitted.
Who? Kindly see the 47. It is your data. It is not the data of the ICI or State Bank or the petitioner. You have a writ petition? You kindly come to the 47. You are only till September 2024. Yes, September to August 2025. Then, so how your civil will say till 30th September 2024 you are having the details 41 lakh dues. What due?
As per instruction, they have given this updated.
No, they might have been given. You have, after getting the writ petition, you are not reading the writ petition. You are not telling the report and the authority given the report and the annexer.
We have made
Whatever the authority is giving, you are producing the code without going through the writ petition and without going through the report.
Well, may I assist your lordship? Well, so far my knowledge goes and my instruction is till the time there will be default, they will update that report with the civil. After bank gets the entire payment, there will be no updation and for default, because this is for default. And that is why, my lord, NDC was issued, which could have been produced before the SBI saying that, see, I have paid the entire amount, this is my NDC.
No, that's why it is that I appreciate. But his specific case, you have given this NOC. After the NOC approach the SBI, SBI selling that you are having due with regard to the civil report, and civil report says that 14 October thereafter there is nothing.
There is nothing.
Nothing, and they are producing the report. They are updating the report only September 2024.
Well, till September 2024 there was due. That is what showing in the report.
That's why the State Bank is showing. Why?
as per.
This is the everyday. It is the online.
But as per civil, you cannot change or make any
Just
correction.
as per
It is
section
kindly
21,
47. See the 47. When? Learned Council appearing for the civil. Respondent number 5 prays for time to take instruction and to file report. Let the matter appear on 13th of August under the same heading. Within 10 minutes. Yes.
Affidavit of service may be.
Affidavit of service kept with that. Yes, next.
deeply
হ্যাঁ হ্যাঁ কবে রিটার্নেবল হলো এটা?
My lord, before my lord takes up the SIR matter, my lord, 11 to 14, my lord, Rohingya matters, my lord, had directed to be fixed within the first 5 matters, my lord. However, it is not reflecting in the first 5 matters.
Which matter?
My lord, 11 to 14, my lord.
11 to 14.
Yes, your lordship. We can
See if that 2 p.m. matter is not 2 p.m. matter is ache ki? Come at 2 p.m. It will take up.
It will be taken up.
If 2 p.m. matter is not there, then it will be taken up. Yes, item number which seat?
Your lordship, may I hand over the list? I have given the page numbers. The on the
181.
fifth column with the district is mentioned the page number of the appeals. Rather, তুমি ও নিও না।
Or page 19, my lord, I say before the appeal preferred.
Record a note. You are having the draft order. So item 181, same order. 182, same order. 183, same order. 184, same order. 187, 185, 186, there is a difficulty. 185 and 186, there is a difficulty.
Your lordship, in 186,
Well, 181
I have not received the copy.
But 181 and 182 are my matter.
180, who is appearing for 185?
185, I am appearing, my lord.
Yes, no online appeal.
My lord, this is a manual appeal, my lord. My case is before the DU, not before the tribunal, my
No
lord.
order. 186 also no order. No copies out. Who is on 186?
My lord, 186, my lord.
Why your copy? Sir, the copy come tomorrow.
Tomorrow.
185, 186, no. No order. 187, 188, 189, 190, 191.
192, no, my matter.
192 is appearing.
I am appearing.
What about now 191 to 192 to
My
197?
lordship is yet to provide.
My name has not been deleted, my lord. Only my lord, my matter is pending, still under adjudication. I have some copy of all the respondents, my lord.
To let it appear tomorrow, my learned friend could provide the scanned copy. Online join করে নিও, কোনো অসুবিধা নেই।
Tomorrow is court, sir.
191 disposal.
88 and 1.
Just a minute. So 192 to 198, there is a problem.
Your lordship.
192 to 198, no order, huh? Not today, Kori.
Scanned copy.
With 199. 199,
199, your lordship, is under adjudication.
so no order.
No order, is still pending before the administrative side.
And 200,
200, your lordship, it's not a SIR matter.
not SIR matter.
Not SIR.
Why application 200 is separate matter?
हाँ.
Let it be next week, any.
ঠিক আছে 200 একটা কাজ করুন 200 ডিলিট করে দিন এটা নরমাল ম্যাটার নট এসআইআর ম্যাটার
My lord, any day next week, my lord, if your lordship kindly fix one.
not today no SIR matter and 201 also who is appearing for 201 oh, that is also you are not saw the copy no order
Copy has been served.
কালকে তো আজকে
not
দিয়ে দিও।
today 202 not today
Matter was hard, Calcutta tak better. But matter was hard on education.
then 203 204 205 206 207 208 209 210 211 212
দরকার নেই তুমি আমাকে দিয়ে দেবেন পেজ নাম্বার এইভাবে বাড়িয়ে নিয়ে আসবে
not today 14 not today
আমার কথা
213 not today 214 not today ঠিক আছে then 215
your lordship, in item number 112, the petitioner is
250
filing a supplementary appeal.
215 order 216 217 218 219 220
201 fine.
221 222 223 224 225 26 27 28 29 30 31 32 not today 33 not today
Your lordship, item number
31 order pass 232 233 no order Not today.
The appeal page number.
Then 34 disposed of, 35 disposed of, then 36, 37 not.
Scan for a copy.
36, Lord.
Ah.
36, my Lord. State of West Bengal has not been made party, but a copy has been served.
But why, what about the 236, 237?
234 and 235 are deleted. They have to file Form 6. Separate order.
So then get it 234. No, only up till 231. Yeah, up till 231. Acha, now, yes, 236 who is appearing? 234 who is appearing? 234 who is appearing?
Lordship, I am appearing in the.
Yes, your name is deleted. What can be done?
Lordship, I preferred an appeal, your Lordship. Petition. 234 and 235, your Lordship. My name was deleted in the 28th of February. I have preferred an appeal under Representation of People Act, Section 24A.
Where you have preferred?
Appeal is still pending.
Where you have preferred an appeal? Before the tribunal or before the DO?
Before the TEO,
TEO.
District Election
Then-
Officer.
then what
That
has
appeal is still pending, your Lordship.
34.
234 and 235. My
34.
appeal number is 57, your
34,
Lordship.
I record the order. Leonard Cons 234 and 235.
235.
You are a writ petition?
Yes, I have the
Give-
petition, your Lordship.
You give, yeah, there, yeah,
এটা
it there.
দিয়ে দাও, এটা দিয়ে দাও। এটা appeal করেছো।
And Leonard Counsel for the petitioner submits that after the deletion of the name of the petitioner from the voter list, comma, the petitioner has preferred an appeal before the district election officer on
234 এর নাম কি আছে?
19th of March 2026. 2026. But the said appeal is still pending before the district election office. In view of the submission made by the counsel for the petitioner, the district respondent number, the district election officer is directed to consider the appeal filed by the petitioner and to pass appropriate order in accordance with law within a period of 3 weeks from the date of receipt of this. 235 also same. 234, 235 same. Same. Who is 36?
36, my Lord. I appear for the state.
Hello.
State has been served, but state has not made party in the proceeding.
Who is in 36?
Petitioner কে আসতে দাও।
Who is in 236? Nobody's. Who is in 237?
I'm for the petition. I'm for the petition. Lordship.
Yes,
Their
what?
name has
Not
been
today,
put under adjudication, your Lordship.
185, my Lord, your Lordship.
Just a minute. 236?
I'm 37, your Lordship.
Yes. Madam, 237, you have a copy?
Since you
Scanned copy.
I have to send it.
Not today. 236, 237, not today. Yes.
My Lord, 185, my Lord. This is also a matter, my Lord, where appeal is pending before the DEO.
185.
Yes, my Lord. My Lord, I have a copy of the writ petition. May I?
Where is the copy? Where is the writ petition?
My Lord, I am giving the writ petition, my Lord. This is a manual appeal pending before the DEO. DEO.
Not 185. 185. 185. Leonard Counsel for the petition submit that after the deletion of the name from the voter list, comma, the petitioner has prepared an appeal before the district election officer on 5th of March 2026, and since then the appeal is pending before the district election officer. Considering the submission made by the counsel for the petitioner, the district election officer is directed to consider the application, consider the appeal filed by the petitioner dated 5th of March 2026 and to pass appropriate order within a period of 3 weeks from the date of receipt.
Grateful, my Lord.
Yes. Any further?
My Lord, 191, my Lord. My Lord, the passport is expiring. My Lord, a passport is expiring on 11th September, my Lord. My Lord, can it be
My Lord,
considered within 1 month, my Lord?
My Lord, 184. My Lord, appeal is pending with the tribunal, my Lord. My Lord, petition is before the landed tribunal, my Lord.
Order passed.
My Lord, appeal is service, my Lord. Kindly, appeal is service.
Not.
Yes, also 199 and
what? Yes.
Your Lordship, 190 before my lord rises, my lord. Before my lord rises.
198 and 99.
Before my lord rises, my lord. Item number 3. My lord, your lordship was pleased to pass an interim order. My lord, the only my lord I also missed out. My lord, your lordship has recorded that we are the participants. When we are the suppliers, we are complaining on twofold. First is with respect to the 3 companies being foreign. The other one is that only why 3 companies, there are other companies also who can participate. So, my lord, we are the suppliers. No, it is not participant, will be suppliers. Only, my lord, that correction may be made.
Great.
Minute one submission.
Let I am not pass any order.
Minute one submission. Item number today's at daily is item number 1339. My lord, Advocate Commissioner given a notice to the petitioner. Today is the last ultimatum for the vacating the premises. My lord, kindly fix it now. Next week. It is a read petition.
May I will leave lordship, I am mentioning very under compelling circumstances. There is another SIR matter which was mentioned on 29th of June.
List tomorrow it will appear.
Okay.
It will remain in the list. Two such that is remain in the list. इटा रखो मेरे को चंदन में दे
कोई ज्यादा क्या दे
State court. My lord, none of the occasions, my lord, it is on our behalf that time has been taken. My lord, on the last occasion, lordship was pleased to observe that the learned advocate appearing for the state is not in a position to assist this court. But I have annexed these orders, and my lord, this is my prayer, kindly be listed tomorrow, my lord. Extreme urgency is involved.
But tomorrow the other party will appear.
My lord, we will immediately serve the notice. We have already tried to inform them. We'll again immediately serve the
Here the
notice.
AG
It's a
is-
question of law, my lord. Just remember
That's why
the
AG is required to appear in the matter.
Yes, my lord. We have served the Northern AG the copy of the writ petition, my lord. We'll inform him again, my lord. I'll inform him personally after this mentioning.
Hmm.
My lord,
what
kindly
will
takes
happen?
it up tomorrow, my
Why
lord.
it is not appeared?
My lord, what is happening? State has appeared.
On
13th, the matter was listed. Directed to be listed, my lord, on 13th. My lord, upon my lord service of the learned AG. My lord, somehow, my lord, the matter has not come up till now. But this is the situation, my lord. I am praying tomorrow, my lord, as your lordship, my lord, if it comments to your lordship, my lord. Because lordship knows, my lord, this is a pure question of law in any event. Because we have challenged the Registration Act non-compliance. I am most grateful. My lord, any my lord, positioning of
issue notice issue. Tomorrow there is no time. All the matters taken.
all the matters, my lord. Very well, my lord. First 20 or 10 matters.
That will be there.
Grateful to your lordship.
Within उसमें कर देना within 10 कर देना.
Lord, may I permit to mention this SIR matter?
Yes, call the list.
May I permitted to mention my
No mention.
yes, sir. My lord. My lord, 183 SIR matter already taken up. My some urgency is there, my lord. My appointment is pending. In Alia University, my lord.
My lord, item number 11 to 14, my lord, had directed the state to take instruction from the civil authority. What are the guidelines with regarding to the petitioners who are languishing in the correctional home despite completion of their imprisonment, your lordship?
Yes. Item number
11 to 14, your lordship.
Yes.
Connected.
Oh, man.
My lord, in the FRRO order, my lord, they have spoken about a detention manual, my lord, 2026. My lord, perhaps that would contain all the
Loknath Das से no अब state के
Yes.
आप बोले ना कोई बात
Center is depending upon the state.
Yes.
That's because
And that's a wonderful coordination. Wonderful coordination. And with him also being there, physically we are seeing here. So that's also great for us. Malad, we've obtained instructions. Malad, as per what we've been told, if I can hand over Malad one sample instruction for Malad. I'm sorry, Malad, it's not staged.
कोई बात नहीं हमें बाद में ये तो स्कैन नहीं हम दे दिए स्कैन कर लेगा बच्चा
हाँ, एक ही कॉपी है
कोई बात नहीं स्कैन हो जाएगा
My lord, will be pleased to take, my lord, the Home and Human Affairs Department, Government of West Bengal has issued a circular of 23rd May 2026 to all the district magistrates mandating setting up of holding centers across the state, my lord, for apprehended foreigners as well as for released foreign prisoners. My lord, we are on the second part, my lord, awaiting deportation, repatriation in accordance with the MHA guidelines. My lord, then, my lord, the circular Home and Human Affairs Department follows the guidelines set forth by the Ministry of Home Affairs. My lord, next, my lord, I am directed to inform state government will have no objection if the writ petitioner, my lord, is transferred to the holding center of the concerned district from its present place of detention at the district correctional home till his deportation or repatriation process is completed in accordance with law. My lord, in the last occasion, my lord was inquiring, my lord, who's the authority. My lord, superintendent of the concerned correctional home may be directed to take up with the concerned district magistrate for completing the procedure of transfer of the writ petitioner from the correctional home to the holding center. My lord, so this writ, my lord, can be, my lord, decided, my lord, upon them being directed to be, my lord, presented before the holding center, and then, my lord, subsequently, whatever steps the government of India needs to take will be taken up. My lord, the next, my lord, will be pleased to take, my lord, the next 23rd May 2026.
Enclosed, my lord, I'm placing. Enclosed, please find the letter and the reference regarding the procedure to be followed for deportation of Bangladeshi Rohingyas apprehended for staying illegally in this country. In this connection, it is requested to take initiative, appropriate action for setting up of holding centers in the districts for apprehended foreigners as well as for released foreign prisoners awaiting deportation repatriation in accordance with the MHA guideline under reference. My lord, the next, my lord, has seen, my lord, this is, my lord, the procedure for the government of India's, my lord, procedure for deportation of illegal Bangladeshi nationals or Rohingyas. My lord, here, my lord was pleased to take, my lord, the internal page 3, my lord. Pagination is at the bottom of the document, my lord. Internal page 3.
Yes.
My lord, point 6, my lord. The foreigners regional registration officers and foreigners registration officers, who are generally the district SPs or DCPs, are the civil authorities under the Foreigners Order 1948, and they are also registering authorities under the Registration of Foreigners Rules 1992. As a civil authority, district SPs or DCPs who are designated as foreigners registration officers are responsible for implementing various provisions of the Foreigners Act 1946 and the Foreigners Order 1948. Where an FRO is not available, the FRO concerned may undertake these functions. Adequate powers are vested with the state governments, UT and administrations, FRROs, district SPs or DCPs who are designated as FROs for taking appropriate action against foreign nationals who are found violating the visa conditions. So, my lord, here the power of the civil authority has been given, my lord, to the district SPs or DCPs who are designated, my lord, as foreigner registration officers. So, my lord, this is the government of India guidelines. So, my lord, apropos these guidelines and, my lord, the direction of the state government to set up, my lord, holding centers. Holding centers have been set up, my lord. In South Bengal, there are 2 holding centers. In North Bengal, 1. That's what, my lord, my oral instructions are. So, holding centers are available, my lord. They can now be transferred. My lord may be pleased to consider directing the concerned, my lord, district correctional home superintendent to coordinate, my lord, with the district magistrate for completing the transfer. My lord, if my lord so deems fit, my lord may be also pleased to give some time limit within which this has to be done. So, my lord, this can be effected, my lord. So, in order to bring it to conclusion.
My lord,
As far as Union of India is concerned, it has fallen from your lordship on the other day that what are the process being followed by us? So, lordship in a sealed cover. Yes.
my lord, on the last occasion, had directed like which SP would be termed as the, my lord, the civil authority.
In the sealed cover, the process which we followed.
Yeah, that's I want the categories of foreigners whose movement is restricted in the holding camp. So, because that's why for following this, the civil authority is required. Civil authority will take the charge of this convicts from the correctional home. They will take to the holding center and they will pass a order, restricted order upon these persons, which area they can go and they can, and all those things is there.
Same for us.
In one matter I appeared long back, 72 Arakan army persons have been arrested, and that was in Campbell Bay. Then Justice Sinha was holding the circuit, and they have been detained with arms. So Chief Judicial Magistrate told me I have to accompany. Well, I will accompany, but we'll go by the ship. By that time, the 48 hours will be over. And the naval ship was we had been there, then the custodial order was passed, brought to the Port Blair, then the procedure was stopped.
But these Arakan, they were from the Arakan armed forces.
This Myanmar's.
Oh,
Myanmaris who have been
yes, because there
who are agitating from the Myanmar, so they have been segregated. So they have created a arm. So that the name has been given Arakan armies, and they are very dangerous. Very dangerous.
Well, parts of the, my lord, the India-Myanmar border is under Arakan control at the
Arakan,
moment. That
yes.
is why there is a civil war going on in the country.
And they will go with the Indian boat miles together. They are not required for any modified boats. They will go by the simple engine boat for miles together, either cyclone or whatever.
It is all here. I have, because mentally, if you are prepared, these atrocities do not matter. But your ideology should be in place.
And no. And another thing I am telling, another thing what correct. Correct. FRR, see, first thing you have to come out, you have to take a note from the correctional home. Then your movement is to be restricted. Then the FRRO, which will take the steps for your repatriation. Till your repatriation is being done, then the authority, the FRRO or whatever the civil authority will take care of his whatever the daily needs and what is the restriction where you to go and where you to come. They will take care of it under their custody. You will be there in the home, and if they will go, the restriction is fixed, and that restriction only you can go free. This is 2026. Amenities to be provided to the holding center shall be set up. That page is missing. Mr. Trivedi, the total copy has not been given. Amenities provided to. Okay, let they comply with the deportation manual 2020. Okay. So I am disposing of this. Correct. I am disposing of this, directing the superintendent correctional home immediately make the correspondence with the district magistrate as well as the civil authority. And the civil authority will take, if the civil authority is coming to the jail authorities, they will be released from the jail authorities and they will taken to the holding house and holding shelter. And after the holding shelter, the civil authority will take appropriate decision in accordance with law.
If my lord, I can make one innocuous prayer, if my lord keeps it pending until they are transferred to the holding center, because my lord, again, it will take my lord 1-2 years.
I am
and-
fixing at the time.
Yes, your lordship, my lord kindly fixes a time and my lord keeps it on the next date, my lord, the union and the state can come up and submit a report, my lord.
Why you are worrying?
Apprehension. We are
This
having
court,
our food.
I will pass appropriate order immediately within a.
And apprehension.
My lord, the case has been pending for so long.
For the last 3 years, they were not getting the holding house. Now they were searching of the securities.
My lord, because this has been pending for quite some time. If my lord keeps it pending for one more month, my lord.
For what?
My lord, let them.
See, I am telling, I am what I order I supposed to pass. I am telling you, within a week I will direct the superintendent. Within a week from the date of receipt of this order, immediately contact and make a appropriate communication to the district magistrate as well as the civil authority. Correct. And on receipt of the request of the jail superintendent, within a week the civil authority as well as the district magistrate shall take appropriate step for shifting these petitioners from the correctional home to the holding house. And once they have been shifted to the holding house, the authority will take appropriate step along with the government of India for their deportation.
My lord, just to bring to your lordship's notice, there are other Rohingyas also, my lord, who have completed the sentencing.
Fine, you have made a request to the jail superintendent. If they are not considered, then you have to come.
If my lord kindly adds that upon request to the superintendent, if that, because otherwise they will all have to come.
How many persons are there?
My lord, to my knowledge, my lord, I know of 16, including this 16.
And this is one correctional home. So other
Yes.
correctional home?
That I am not aware of. My lord, there are more in this correctional.
You do one thing. You do one thing. You take the data how many Rohingyas are in custody after completion of their, because as per the Supreme Court judgment also you have to give the data. Correct. You take so that I can pass a comprehensive order. So time and again the petitioner could.
In case there are others, I will obtain the data in the meanwhile. But in case others come up before then it should be treated on a case basis.
Because
no, that's why this court didn't want that every person should come to the court. Once it has come to
yes, your lord.
then a comprehensive order will be passed. It will be circulated to all the jail authorities and the district magistrate. 2 weeks. Why? If you go to the correctional home, there is a board.
Yes, your lordship.
You will find how many convicts of foreign national, Indian national, you are inspected. I have experience on that.
There is a list of released prisoners, my lord.
So there will be a board. How many, every day they have to change. Once is convicted, once a bail, under trial.
In fact, wardens not even carry arms inside. They carry sticks. Because arms they get snatched.
They can't. Only in the watch house. They will be they will keep the arm.
My lord, the list of the released prisoners with respect to Rohingyas is available with the superintendent's office. My lord, it can be easily available.
One thing, you do one thing. I am fixing after 10 days. You take the total list so that a comprehensive order can be passed and it can be circulated to all jail superintendents. Matter can.
And also to which district, my lord?
As far as these matters are concerned, but making one matter and subject correction. But all these, maybe needs to pass separate orders because districts are separate.
Yes, your lordship.
So that's why that can be circulated to all district magistrates, to all the correctional homes.
These 4 matters, take them separately. That's as far as these 4 matters are concerned. But if I will obtain the data if it's so possible.
The petitioner has filed the AC kya hua? The petitioners have filed the present date application. Petitioner, sole petitioner. The petitioner has filed the present date application. praying for a direction upon the respondent authorities to release the petitioners who are at present in Damdam District Correctional Home, even after completion of his sentence passed by the Learned Trial Court. Police. And counsel for the petitioner submit that the police of PS, which PS it was? PS?
My lord, this was Swarup Nagar.
No, Jinamtala.
Jivantala PS, my lord.
Jivantala PS. Police
Case
of
number
PS
67.
Jivantala had initiated an FIR, being FIR number 67 of 2021, dated
20th February 2021.
no 29th February. Where is the date of the FIR? 20th February 2021 against the petitioner for the offence under section
14 foreigners, Act, your lordship.
14 only 14A 14
just
section
14.
so
Page
14
18.
Foreigners Act, section 14 Foreigners Act. ठीक है? Since the arrest, the petitioner was arrested on 19th of February 2021, and since his arrest, he was in correctional police. After the filing of the charge sheet, he was tried or he was pleaded guilty?
I pleaded guilty.
After the filing of charge sheet for the offence under section 14 Foreigners Act, comma, the petitioner has pleaded guilty. On 7th October 2021.
My lord, pleaded guilty. My lord, the order is
7th,
on
23,
7th
page
October
33.
2021. Yes,
Pleaded
your lordship.
guilty on 7th October 2021.
For 9 months.
And accordingly, the learned trial magistrate has imposed sentence upon the petitioner to suffer simple imprisonment for 9 months and to pay fine of rupees 3,000 in default to suffer simple imprisonment for 30 days further. It was also recorded that the detention period of the petitioner may be set off, that is from 20th February 2020. 19 बोला ना 20 कर देना 19 February से correct में बोला ना 20th February 2020. Full stop. Land Council for set off, that is from 20th February 2021. Land Council for the petition submit that since 20th February 2021, the petitioner in correctional home, in spite of completion of his sentence imposed
20th November, my lord. 20th November 2021, he completed his sentence.
20 February 2020, in spite of completion of his sentence on
20th November
20 November
2021.
2021. 20 November 2021. Police. The Land Council appearing for the state has submitted the report dated 28th of July 2026, wherein it is mentioned that the Home and Hill Affairs Department, Government of West Bengal, has already issued a circular being memo number 185-FNB/S-29-2026 dated 23rd May 2026 to all the district magistrates mandating for setting up of holding center inverted comma across the state for apprehending foreigners as well as for the release foreign prisoners awaiting deportation / repatriation in accordance with the MHA guidelines. And Council for the State further submits that that in terms of the set notification already has already issued a circular so and so holding. Council for the respondent further submits that in terms of the said notification, holding centers have been set up and if this court pass an order directing the superintendent of concerned correctional home to coordinate with the district magistrate as well as the civil authorities, the petitioner who has already completed his sentence, still he is languishing in the correctional home, can be shifted to holding center, and subsequently the authorities, the government of West Bengal shall take appropriate steps in consultation with the Ministry of Home Affairs for their deportation or repatriation in accordance with the MHA guidelines. Full stop. Had the learned counsel for the respective parties peruse the report submitted, peruse the materials on record and the report submitted by the state authority. Next, learned counsel appearing for the Union of India has submitted the manual, the exact portion and the extract of the deportation manual 2026 and submits that the authorities will take appropriate steps if the petitioners will released from the correctional home and be taken to the holding center in accordance with the said manual. Full stop. At the land council for the respective parties peruse the matters on record and the report submitted by the state. Full stop. As per the procedure for deportation of the illegal Bangladeshi national Rohingyas, the Government of India Ministry of Home Affairs has formulated a scheme wherein clause 6 reads as follows. In the present case, the petitioner is in correctional home since 20th February 2021 and he has completed his sentence on 20th November 2021. Still the petitioner is in correctional home. Now the state government of West Bengal has made and has already taken steps for setting up the holding center and the petitioner can be shifted from the correctional home to the holding center. Accordingly, the jail superintendent Damdam.
Yes, Your Lordship.
Jail superintendent of Damdam Correctional Home is directed to immediately within a period of 1 week to inform the district magistrate as well as the civil authority with regard to shifting of the petitioner from the correct
district superintendent, if I'm not
district jail superintendent. Look,
SP is the civil authority.
no, the district superintendent of the correctional home. Correctional home is the superintendent. Superintendent correctional home. And the civil authority, that's why I'm given because here they are not notified, whether SP, ASP, whatever it may be. Then tomorrow he will say there is no AS. He will say. Damdam Correctional Home is directed 1 week. Shifting of the petitioner from the Damdam Correctional Home to holding center, and on receipt of the request of the superintendent Damdam District Correctional Home, the district magistrate as well as the civil authority shall take appropriate steps for bringing the petitioner from correctional home to holding center. Full stop. Sapera. It is further made clear that once the petitioner is brought from correctional home to the holding center, the civil authority will take appropriate steps in accordance with the take appropriate steps in accordance with the guidelines issued by the Government of India Ministry of Home Affairs within bracket Foreigners Division dated 2nd May 2026 as well as the deportation
2025,
manual
Your Lordship. Lord, it's dated
2025 and the deportation manual 2026. ठीक है? With the above observation, the writ petition is disposed of.
Malad, the Damdam Central Correctional Home. Malad.
Damdam Central Correctional Home है ना? Damdam Central Correctional. Anything further? Otherwise, your authority will be confused.
Yes. Because there are three districts, North 24 Parganas, South 22 Parganas, and South.
So that's why I recorded the main district superintendent. So which it will go. Otherwise, they will go roaming here and there. एक काम करो, this order may be communicated. The office is directed to, the registry is directed to communicate this order to the superintendent. Superintendent क्या बोलते? दमदम सेंटर क्या बोलो? District Damdam Correctional Home as well as the district magistrate for taking appropriate steps for compliance code. In the meantime, if other matters will come, you keep with the matter. If other matters will come, then it has to be one order can be passed. Huh? And this is all the 11, then 12, 13, and 11, 12, 13, 14. 11 to 14, but 11, give 11. 11 is over, na? 12 is the
12 is Faridul.
This is which correctional home?
So same, they are all in Damdam correction.
All that Damdam. And he was when what is the date of the FIR?
FIR is on 9th February
FIR
2016.
इसमें देखो FIR number 37 of 2016 dated 9 to 2016.
9th February 2016.
Since when he was in custody?
9th February 2016.
Since then?
Yes, Your Lordship.
You are great.
It is coming from my heart, but Malad less of the better Malad.
They completed their sentence on 3rd July 2008. Malad, the order is at page 38, Your Lordship. Then 37. 37 years, Your Lordship. 1 year, 3 months. Third July 2018.
So this is 12. But this is not 24 per.
Same correction.
FIR is of the FIR 9th October.
Sentence to 3 months. Sentence to 3 months. 25 page number. Three months. Tenth January 2017. Same Swarup Nagar PS man. 815. FIR is 819 of 2016, 9th October 2016. Same FIR. Yes. Is my lord not keeping one pending with regard to the, my lord, the other released prisoners? My lord? No, my lord. This is your. No, my lord, they do not have the means to engage a senior as well, my lord. That is why I am appearing.
You are senior most. You are the legal aid and on you films will be made in Bangladesh. You are giving a run to all of us for money.
On this matter because she came up before matter. So
But he is the sole crusader. He is. Yes. Yes. Very, very commendable.
I'm grateful for your lordship.
But then I have advised her that ask your client. Very commendable, but I have advised her that we are already 140 crores in India. Please advise your clients.
my lord, experience us spending on them.
In the correctional homeland, they are better less. They are getting everything. They are getting money also.
No, my lord, they do not get because they were not sentenced to rigorous imprisonment. That is only for rigorous imprisonment, your lordship. So, my lord, their labor is for free, my lord. And my lord, once they complete their sentence, also, my lord, the money stops. So, my lord, that is free.
These are the antidotes of a matter which happens between the bar and the bench. Some humor is required, Milan. Yes, Milan. Humor is required for us also, Milan.
Someone from 2016. Something has come to it. That is one. That is.
Yes, Milan.
Hopefully. Yes, your lordship.
There are many petitions which
Yes,
Yes,
your lordship.
Earlier, they were sent to Delhi. Telangana, I've seen those orders, my lord. But Justice Deepak Datta sitting here, my lord, as lordship then was here, my lord, passed an order for Delhi. There was nothing to keep them here. And these are issues of national security.
Yes, sir.
Nothing. My lord, now that the matter is over, while I was speaking, my lord, to their officials, one officer, my lord, tried to build a holding center, my lord, sometime back. That officer was suspended because he tried to build a holding.
At that point of time, nobody was found to be.
My lord, just to bring to your lordship's notice, even the one in Delhi, my lord, there is no official detention camp, my lord. It is run by NGOs unofficially. So, my lord, the government of India does not have, my lord, probably the West Bengal is the first where they have holding centers, as probably in Assam as well. However, my lord, I have made RTIs, my lord. There is no detention camp or holding center in Delhi or Telangana. They are all unofficial, run by NGOs.
Because, I suppose infiltration was very easy in Andaman Nicobar.
These are issues of national security also at a deeper aspect. Very important. But today the floodgates open. It's a serious issue. But we are seeing that in Europe. Yesterday, Spain only thousands from Morocco went into Spanish territory. Yesterday, that we are seeing.
Yes, your lordship. No, my lord, they went by sea, my lord. Yes. Yes, your lordship. Yes, your lordship. However, my lord, these are
terrorist attacks. I've seen it.
Yes.
However, my lord, the issue with Europe is that they went there first, so they will have to. It's homecoming, my lord.
I say, no, but I'll say go to Pakistan, please.
how all the Indians have now colonized my lord Britain. In London, there are more Indians than white people now, my lord.
Not Indians, I have been there. They are most Pakistanis. I have been also, you know, discussed as Pakistanis. And it is not Indians in England, it is also Pakistanis. When I went there, I was thought to be a Pakistani only. So it is identity crisis.
Yes.
Yes, well, that's what I'm saying. Because the language is the same, it becomes very difficult. Bangladeshis and Pakistanis.
Well, one time I boarded a bus in Chelsea, my lord. Even the bus driver was brown. The passengers were brown. Not a single person inside was white, my lord. Reverse colonialism. My lord.
Here they were white. Here, so everybody is brown. Even coming, it is becoming difficult for us. I'm grateful, Milan.
Great.
Friday afternoon, Lordship will kindly bear with us.
Grateful.
Grateful, Milan. Great.
Come tomorrow.
Milan, chief.
My lord, so I'm for the petitioner, my lords. Let's
It was filed in receipt. Profit.
But it was filed originally before under Group 9. Sir. Let's.
16, my lord, I'm appealing for the petitioner. Which response? But my affidavit of service, I'll tell you, lordship. Yes, what has happened, I have taken a loan from Manappuram Finance, Gold Finance Limited by mortgaging certain valuable golds, my lord. I have been diligently paying off the EMIs. Now, all of a sudden, my lord, in September 2024, my lord, I came to learn, my lord, that my loan account has been system blocked because they have got to know, they have got some intimation from some authority that there has been a disputed transaction, my lord. If my lord kindly takes up, first, my lord will see. I think the state is asking for time. The main party is the Manappuram.
From one of their customers, 17,000 for the repayment of the loan which they have taken. But I have instruction from High Court. I will send over.
একটা copy দেবেন।
Kindly see the first page. Complaint from Kotabai Parma from Gujarat regarding this 17,000 transaction which was made on 17th of August 2020 and 17,000 and this transaction was made on 17th August 2024. It is there on the second page. There on the second 17th. That is why we have hold up. Complaint. But we were intimated of this and in compliance of the High Court rules, we were.
I made investigating authorities also a party. Respondent number 7.
Yes.
I have not received any intimation. I have come to know from the reply of to my demand justice notice. If my lord kindly comes to page number 39. Page number 39, that my lord is a letter of my learned friend's client, 14th April 2026. My lord, in the third paragraph, my lord will find that they have mentioned about, so in the second paragraph, my lord, that it is noticed that your client is accused in a cybercrime complaint filed via the Indian Cybercrime Coordination Center by Mr. Nasivai Kotabhai Parma, the same person, through Gujarat Narmada Sagbara Police Station. This is for the first time because I have not received any notice under section 35 for investigation, my lord, and no order under 107 has. My instruction, because my account has not been freezed. Because there would have been some transaction, but my bank account has not been freezed. It is the loan account from where from my savings bank account, the money used to go to the loan account, my lord, EMI. That loan account they have freezed.
On the basis of this.
And surprisingly, my bank account is not frozen.
I will regularize the account, but I'll keep this 17,000.
Yes.
Is that?
Yes. Because I am ready and willing. My prayer is that I'm ready and willing to pay the whole amount of loan in one go. It's a small loan. Only thing that time I was in need of money. So I have mortgaged some valuable jewelry, which is my mother's jewelry, my lord.
But I'll set aside. Whether I'll keep the 20,000 aside and I'll not consider that as a repayment of the loan.
Very well.
The investigation. And if the investigation is in their favor, but within 2 weeks I can give them that amount without interest.
Yes. My lord, it was stopped, my lord, in September 2024, my lord. 25th September. NBFC. Response number 2. And I can pay off them the amount and take back the, yes. Grateful, Lordship.
My lord, item number 15, just a small indulgence, my lord. May I be given leave to amend the form, my lords, because it is mentioned as 19 bloods. No, bloods. Bloods.
17 and 18, Lord, are the matters, Lord. I was trying to get this matter heard for your Lordship. Yes, I think, Lord, I can conclude. So the issue with your Lordship today is, Lord, a particular notification was floated, Lord, by the government of West Bengal in the year 2010. Lord, after 2010, a slight clarification was required regarding who are the employees on which, Lord, this particular notification was to be implemented. In 2011, that was done. Now, Lord, the challenge is we are, Lord, these casual workers under the PHE department employed by several municipalities and panchayats. Lord, from time to time, Lord, representations were made, came up before this honorable court. This honorable court directed the matter to be heard out. The PHE department found that the PHE department held that they are not entitled because those casual workers are not against the sanction post. Against that order, they came up before this honorable court. Lord, the honorable single judge, Lord, rejected the contention of the PHE and Lord held that that particular notification is applicable to these kind of class of persons. Now, Lord, against that, the state of West Bengal preferred an appeal. In appeal, it was the single bench order was affirmed, and in addition to that, Lord, interest was
yes,
interest at the rate of 6% was directed to be paid from the date of accrual, that is 2011, till Lord, whichever time the period is. Now, Lord, against that, the state government went to the Honorable Supreme Court. The Honorable Supreme Court dismissed the SLP. Lord, thereafter, those class of persons, Lord, got that money. Now, these persons before the petitioners, before your Lordship, Lord, are on the same footing, same Lord class of persons applying for the same benefit under the 2011 scheme. This is the long and short of the matter. May I take your Lordship, Lord, to the
what is the stand of the authority?
The stand of the authority is again the same old story that they are not casual employees against the sanction post. They are not entitled. And Lord, I have dealt with each and every Lord, part of the report in my affidavit of exception, whereby I have indicated that the names of the petitioners, Lord, specifically are figured out, Lord, from the list of employees of the PH. So, Lord, we are entitled. That's the only difference. May I take your Lordship, Lord, to the notification first? Lord, kindly come to page 43. My Lord is looking into Lord 6520.
Yes.
Yes. Lord, page 43.
Yes.
In order to provide security of tenure, appropriate emoluments, and certain terminal benefits subject to fulfillment of certain conditions to the casual, daily rated, contractual workers. So, all three are going to come, who have remained engaged in the various government establishments for a considerable period of more than 10 years in connection with implementation of various schemes, projects such and such. Lord, this 2010 notification I was indicating, Lord, so.
Who is appearing? You are appearing?
Yes, we are appearing.
Yes.
Lord, such as were issued by the government in finance department. The question of making the provision of the two aforesaid orders more effective and suitable to the convenience of the government establishments has been under active consideration for the government for some time past. After careful consideration of the matter and in supersession of the aforesaid orders and all other orders issued by the other departments in the matter, the undersigned is directed by the order of the governor to say that the government has now pleased to order that the casual, daily rated, contractual workers who are remaining attached to various establishments such and such for 10 years or continuous period of 240 days each year will be allowed the following benefits. Now, my lord, these following benefits I am not disturbing your lordship. My lord, kindly straight away comes to my lord, page 44. The 44, my lord, last, my lord, clause 10. The provisions of this order will not be applicable where contractual engagement has been made without any sanction post. Only contractual engagement. So, my lord, casual and daily rated will not come under this. Kindly turns over, my lord, and my lord, that is also there for a very temporary period up to 6 years. We are, my lord, more than 10 years. Kindly, my lord, turns over to 45.
No, the provisions will not be applicable where the contractual engagement has been made without any sanction post.
And for any specific project
yes.
for a very temporary period up to 6 years.
6 years.
So, my lord, I am more than 10 years and I am not also a contractual worker. Kindly, my lord, turns over to 45. 12. The benefit of this memo will be applicable mutatis mutandis to the panchayat bodies,
ULR and
statutory. So all municipal corporations and municipalities, including the panchayats, will be applicable. Based on this, Lord, kindly comes to the order passed by this honorable court, page 56. Single bench.
Yes.
Second paragraph, I'll take your lordship straight away. The petitioners are all guards at pumping stations operated by the Gram Panchayat under the scheme of PH department. Lord, the same is the case here also. They are on the same footing. They have been engaged by the concerned Gram Panchayat. Their wages are paid by the PH department of the government of West Bengal. Same here. The petitioners have been serving for more than 15 years as guards. There are no sanction posts of guards for the water pumps in any of the Gram Panchayat. Same facts. The petitioners do not seek regularization or permanent absorption in such and such. Each of the petitioners, 3 of whom are retired, had fine. No, this is not here, not there. Kindly not turns over. Para 8 of the next page. The government, realizing its responsibilities to provide some benefits to casual worker, issued the aforesaid circulars, which culminated in the terms and conditions of the one that I just showed to your lordship. By circular, which excluded from its purview persons engaged on contractual basis against sanction post. So I do not fall under that. Lord, kindly turns over page 58. Now, there are the facts recorded in those cases. Lord, kindly comes to paragraph number 12. It is erroneously found in the impugned order that the petitioners were working as contractual delegated workers since 1995. There is no evidence of any contractual engagement of the petitioner whatsoever on record. Same here. The next argument of the chief engineer was, even though the petitioners worked as casual laborers and not as contractual, they were against the posts that were not sanctioned. Same is the case made out in the report. This court is inclined to accept the argument of the learned counsel appearing by the petitioner that the engagement of casual badli such and such kindly straight away comes to 16 and 17 of that page. This court is of the view that the petitioners are clearly covered within the meaning of circular such and such. Let arrear salaries within payment was directed. Now, this was challenged by the state government at that point of time. Kindly comes to page 61.
Yes.
Lordship has seen that, Lord?
Yes.
Two appeals, two separate batch of writ petitions were there. So, two appeals were preferred. It was arguments were made. Kindly see paragraph 2. Learned Junior Standing Counsel appearing for the appellants has submitted that the private respondents were working as guards of the pumping stations maintained at the Gram Panchayat level. Although the pumping equipment and the work is controlled and operated by PHE, none of the private respondents had been appointed by the government, or this was a second limb of defense that was tried to be developed. Learned counsel such and such misconstrued the memorandum dated such and such. He has contended that none of the private respondents were entitled to the benefits of such memorandum. He has referred to various clauses. Those were referred. Kindly comes to 4. Were not engaged against the sanction post. Same defense here also.
Okay, no appeal is
kindly straight away comes to
appeal is dismissed.
No, I'll just indicate. Kindly comes to page 74.
Yes.
Page 20, para 29.
Yes.
The appeal was dismissed with interest. Your Lordship has seen, Lord? Now, this was finally upheld by the Honorable Supreme Court. Page 76.
Yes.
এক মিনিট আমি শেষ করি না, আমি শেষ করে নি, টাইম চাইবে।
So many other copies are there with supplementary exception to the supplementary.
দে ভাই সব দিয়েছিস?
I have only one copy. Kindly spare me for 2 days, Saturday and Sunday.
Because of this, I knew this is going to come, but because of this entire set, I had photocopied and served it. And I served it not back when, I'll just indicate to your Lordship, the 17th of July, indicating 29th, this matter is going to be taken up for hearing.
I have to answer. And that's only 2 days. Because my junior said, yes, copies are here.
Lord, I don't stand in this. I'm not standing there. Even I am accountable, Lord, to my client. কি বলতে চাইছে?
17 only. I am saying
what my license submitted before this court regarding the memorandum and the order of the court. You have nothing to say regarding. But one thing your Lordship can see.
18th.
The petitioner has annexed their engagement letter and only of payment of 2025. Between that 1997, from 1997 to 2025, there is no document to show that they continued their service in this department. Nothing. Nothing.
So may I just indicate the report? From
unless they can produce that document, how can we have to collect this from the municipalities? It is the old document. These are all documents. Daily documents will have to be collected from the master book. Otherwise, we can. But my learned man should produce before your Lordship the document to show that they were in service from 1997 to
2021. Nothing in this.
Lord,
Regarding the judgment of the court and the memorandum, we have nothing to say.
very well. Lord, if this is the short point, then I think other points they have he has considered. He has considered. Lord, kindly takes my affidavit of exception to the report.
Not as.
Lord, kindly takes the.
They are claiming money.
Very
Okay, okay. When you will come?
Any day.
Learned counsel for the petitioners argued the matter at length. List of learned counsel for the respondent in WPA number 25620. No. Where is the other rate petition?
Lord, 18.
You are appearing for WPA number
17. First 8.
6520. 0. Praise for some time. Accordingly, case is adjourned. Let the matter appear. Let the matter appear on.
Kindly allow action by expedition to verify whether they work or not.
But how many times will they verify? They have filed a report.
26.
Yes, you have filed a report. You must be knowing that you have filed a report. Lord, only one thing, item number 17, may I file the affidavit of exception?
Affidavit of exception filed by the petitioner be kept.
To the supplementary.
Affidavit of exception to the supplementary affidavit filed by the petitioner be kept.
Lord, once they took this point, report was directed to be called for. They filed the report, they were dissatisfied, filed a supplementary report. To that period, we have used the opposition.
Yes, call.
And not the other one also. It Arakta affidavit.
Yes, where is the interim order? Item number 52. Today's list.
Yes.
Who is for the other side? Report is? Have you served? Where is the order? Though the matter is listed as item number 52 of the today's list, but due to positive matter could not be taken of hearing, net counsel for the respondent submitted that the report has already been supplied to the net counsel for the petitioner. Counsel for the petitioner prays for time to file exception to the report and also prayed for extension of interim order. In view of the submission made by the counsel for the parties, the interim order is extended till 26th of August 2026 or until further order. The petitioner is given liberty to file exception to the report within a week. This is the matter on 20th August 2026 under the heading adjournment. Yes.
This is item number 2627. Well, the matters are extremely urgent. My lord, 5th January, the matter regarding the removal of the blockade and the guardrails from the main access way to the petrol pumps, my lord. The business has been damaged totally.
Come tomorrow, come tomorrow.
Yes, my lord.
Item number?
2627.
2627 tomorrow.
My lord, time?
2627 tomorrow. Yes.
1 PM or 2 PM.
Tomorrow the whole day. 1 PM, 2 PM. Tomorrow is whole day. The court is here till 4:30. From 10:30, when you get the time, you come and I will take the matter.
My lord, would your lordship kind wisdom permit me to mention item 55 of my lord's today's list? My lord, I have mentioning upon notice. No, my lord, first is the notice. No, appellate side. Kindly see, my lord, the next page, my lord's order. I would only beseech, my lord, let my lord's order be carried out in terms of the and to true spirit, my lord.
Item number, which item number?
55. My lord has said, my lord, this is that Shorai matter. Lordship had extensively. My lord was minded, my lord would hear out and pass a judicial pronouncement. I only seek carried out.
Adverse step could be taken until the matter is heard, so that the matter be heard when we make our.
not seeing other 55 of minors today's list, my lord. All the minors are carried out.
Then come tomorrow.
My lord,
What is the urgency? Tomorrow I will take.
no, my lord,
Tomorrow is the rest.
my lord, I will,
Urgent matter will be taken.
my lord, my lord, if,
Diaries, my diaries.
my lord, if minors would also mind me, my lord, then also I seek minors blessing, my lord. Tomorrow I'd be traveling, my lord. Monday I have outstation High Court matters, my lord. So, my lord, this is my profession. Otherwise, Tuesday, Wednesday, suits to your lordship. This much of
55.
55 minutes.
Though the matter is listed as item number 55 is on days list, but the matter could not be taken up for hearing. And counsel for the petition draw the attention of this court to the order dated 28th of July 2026, wherein this court has directed to place the matter within 10 matters on 31st of July 2026, but the matter is listed as item number 55. In view of the above, let the matter appear on 11th August 2026 within 10 matters.
My lord, since my lord is in session of the matter, my lord, my junior my lord sister has also said, my lord, let my lord, nothing.
They are telling in the court today also.
My
she
lord,
is telling.
my lord.
21. It's come.
My lord has said 11th August within first 5 matters.
10 matters.
5.
Item number 23, my lord. I am praying for extension of time to file the reply.
Who is for the other side?
Grateful, my lord.
There was a direction to file the opposition by 3 days.
Okay, let the remain in the list and we'll see to that. Yes, call. Or is side I will call.
Item 30 mentioned, kindly fix it.
Item 30. Item 30 कल के कोरी थे?
My lord, I have the leave of your lordship to mention this matter, my lord, item 147, my lord, that was mentioned before lordship on 14, my lord.
Which one?
Item 147, content matter, my lord. And your lordship was pleased to direct me that you please file an affidavit, my lord. Leave be granted, I am filing the affidavit, my lord. Subject lordship kindly, the very urgent matter, my lord, since on 10th of April,
Come tomorrow. Come tomorrow.
My lord,
Urgent matter, come tomorrow. 147 tomorrow. 147 tomorrow. And with the condition, if none appears, matter will be appear in November list.
My lord, may I file a supplementary affidavit?
I will take the supplementary affidavit tomorrow. It will come. Yes, next.
Hearing for contempt number 126. We have filed a recalling application, my lord.
Okay, come tomorrow. Come tomorrow. We'll hear all.
Was the last order. But I am looking at the update matter is that our payments are already to the bank management original title leave that there. Lordship directed the bank to file report, nothing has been filed. But some of the difficulties in the interim what has happened. Because they are uploading the NESL portal that I am a defaulter.
Who is for the bank?
But the bank has not appeared on that day. Serve the bank, communicated to the lordship's order. But thereafter the matter was not taken up.
All of this, sir.
What has happened in the interregnum is they are uploading information in the NESL portal that I am a defaulter. Now the bank will initiate SRPC and IBC against me. I have paid all dues of the bank. But this is the difficulty. But item number 115 you keep your logic keeps it tomorrow when I will come and do that.
Okay, item number 155 tomorrow.
115.
115. 115 tomorrow.
Orders were passed to the vacation bank for 22nd of May. I not always passed the I have mentioned about.
Let the interim order stand extended by a week or so, by the end of this month, because next month, because we are yet to file our affidavit in opposition. Time is given for 4 weeks. It is ready. We will be taking a week's extension. By 1 week, we shall be filing in opposition. Writ petition. And in the meanwhile, my lord, what I had indicated yesterday also, the fraud reporting of fraud from the fraud monitoring registry has been removed. So they are not prejudiced in any way. The interim order, which was subsisting on the urgency, that no longer exists. And it has to be heard out on affidavit. Can we go
Land counsel for the petitioner mention the matter and submit that the interim order is till today and paid for extension of interim order. In view of the submission made by the counsel for the petitioner, the interim order is extended till 21st of August 2026 or until further order, whichever is earlier. Let the matter appear on 12th of August 2026. दो matter हैं.
following?
Then 19th. दो order हैं. Same order, two. 185, 186. Yes, next.
My lord, item number 1, I am appearing for the petitioner, my lord. There is an interim order subsisting, my lord. I am requesting for extension of that interim order.
Here, may I be permitted to file my affidavit in opposition?
If a copy can be supplied to me. The email by which it was supplied, it's not opening, my lord. I can show it from my phone right now. Yes. If it can be served.
And the matter is to be mentioned on the prayer made by the counsel for the petitioner. And counsel for the respondent number 2. 2 has filed affidavit in opposition. Officer, after serving the copy and counsel for the petitioner, counsel for the petitioner prays for time to file affidavit in reply. Let affidavit in reply be filed by?
My lord, may kindly give some time, my lord, 4 weeks.
3 weeks. 3 weeks. Interim order is extended till 28th of August 2026. Release the matter on 26th of August 2026.
My lord has recorded a copy has been served. So if they can
give. Write to her.
Right.
My may also be recorded in the order. We have, and on instruction submitted, we have removed the petitioner from the fraud monitoring.
Actor record current. London counsel for the respondent bank submits that the bank has removed the name of the petitioner from the FMR reporting. Take note of it.
Yes,
9 June 2026. Take note of it. If your name is removed, what remains?
So if they are not willing to proceed with it, my lord, we can.
They have removed your name. Okay.
Let me take instructions, my lord, on that. Please.
Very grateful to you. Next. Fraud monitoring report, FMR. Yes. Hearing. Who is arguing? You? Argue today or next date?
Well, I have to it's not feasible. It's not possible, my lord, to conclude as well as my lord. I'm sure, my lord, your lordship will need to be.
Why this before this court?
Because, my lord, I was arguing and I had started my arguments, and it was part heard before. Because the entire evidence was recorded before your lordship. The short point is, Lord, might come back to your lordship. I'm not saying. Bank was my tenant. The lease has expired. There was a clause for extension. We said that we will extend, provided you enhance. We had enhanced it to 55 rupees after the termination. They said that we will come back, and thereafter they came back with saying that no, it is 53. So 55 and 53 were the two points of difference. Thereafter, Miller Bank neither paid 55 nor paid 53, continued in operation and started paying the old rent under the expired lease. Thereafter, the bank, of course, Miller occupied for another.
Have you obtained loan from that bank?
Well, I should have. Thereafter, after 3 years of occupation, they left.
Now, my lord, there are some claim on account of arrears and some claim on account of occupation charges. That's the point.
Don't be nothing. For the civil and.
Bank is a master at that.
Yes.
Bank is a master at that.
Fraud, civil.
Taking the determination of this court, I am thinking the bank is no other work in the Calcutta, West Bengal, other than the frauding.
Fraud declaration and willful default.
Willful default and freezing of the account.
Yes.
Freezing of the account, now like freezing of the account. Immediate freezing, entire account.
Either it's 10 rupees or 10 crore rupees.
Entire account getting freezed.
And they don't even have
That
the
is listed
expertise to draft a proper willful defaulter notice.
In spite of several direction, bank is
They keep on doing the same thing.
The matter is specially fixed today for hearing, but due to paucity of time in hearing, the matter could not be taken up for hearing. Nah, due to paucity. Then counsel for the petitioner plaintiff has argued the matter, but due to paucity of time, matter could not be taken up for hearing. Accordingly, cases adjourned. दो डेट दे दो खत्म करते हैं. 14-15 September at 3 p.m. 15 September at 3 p.m.
Right.
Obliged me.
खत्म करो ये भी है. चलो कॉल नहीं कर.
My lord, Mr. Mitro had mentioned yesterday that he's not.
When it is to be. Huh?
My lord,
It will come on Monday. Same position.
Grateful, my lord.